Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun, enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends. Hello. Welcome. Good afternoon. Today is Tuesday, December 10th of 2024, and it is 1:45 p.m. here on the East Coast. Do you know where your children are? How is everyone? Yes, Luigi Mangione's parents know where their kid is today. And by the way, do I have any Italian friends in the chat? Any of my Italian people in the chat today? Could we please tell everyone that his name is pronounced Mangione? It's not Mangione. It's Mangione. Some of my Italian friends in the chat, please back me up. Luigi Mangione. Born with a silver spoon in his mouth. What a story. Ivy Leaguer. Gunned down, allegedly gunned down, innocent until proven guilty. CEO of United Healthcare, which we covered live the other day. So there's that. His name's Luigi Mangione. Allegedly. Allegedly. Right? There's no E. It's Mangione. Thank you. Mangione. Lady Zelda is going to point out it's Mangione. It's Mangione. All right? It's not Mangione. I mean, what? What are we doing over here? First of all, he needs to start praying to St. Jude, who, as you may know, is the patron saint of lost causes, because what a story that is. But we're not here to talk about that today. We're going to talk about that another day. All I'm going to say is that, Luigi, did you really need a McRib that bad? Did you really need the McRib? I mean, if you know about the McRib. It's not going to be here very long, but really? Did you have to go to the McDonald's? They're actually saying that they are, he was eating hash browns. So I don't know. Maybe the McRib wasn't available yet. Maybe he was going to hang out all day and wait for the McRib to become available. I don't know. You know, it is sometimes you go to McDonald's and it's like, yeah, you can't get breakfast anymore. And you're like, oh, but I just really wanted that McGriddle. I really wanted a sausage McGriddle, no egg or cheese. And they're like, no, you can only have a hamburger. And it's like 10 in the morning. It's like, forget it. I don't want anything then. Well, like Sarah would say, Sarah Boone would say, it's going to be a good day today. It's going to be a good day. Today's going to be a good day. Not only did I go to yoga today. What? Yeah, I'm all in the namaste. So don't anybody mess that up for me today. Mods, zero tolerance. My namaste is going to stick with me for a little while today. The other amazing thing that happened, and really, quite frankly, I think I might have to go buy a lottery ticket after this happened today. Okay, wait for it. Brace yourselves, because this never happens. I was in the Ticketmaster pre-sale queue, if you know, you know, for the Sphere Dead and Company run that is coming up next March, April, and May. Pre-sale queue of Ticketmaster. You know how that goes, right? It like every refreshes it, and then you're in the queue, and there's 982 people in front of you, and then 753. And then what usually happens is when you get into the room, the virtual waiting room of the Ticketmaster, you put the tickets in your cart and they're gone. And that's like, oh, sorry, try again. Sorry, try again. And then you waste an hour of your life trying to get those tickets and you never get them. I was in and out of the Ticketmaster queue with my floor seats by 1:06. It opened at 1. I'm going to go buy a lottery ticket today. That never happens, right? I know. Somebody said last time I ordered from Ticketmaster, I was physically standing in line. Yes, or Ticketron. Didn't it used to be called Ticketron? Oh, Jonathan. Oh, Jonathan. Jonathan is my amazing secret behind the scenes paralegal. And he just literally came up with 2 more documents like Karen Reed. So we have so many things to go over today. But yeah, I remember sleeping outside of Ticketmaster in the car at Roosevelt Field or outside the UMC at CU Boulder, waiting for those tickets to go on sale for the Grateful Dead at Red Rocks with Jerry. Don't hate me. With Jerry. Saw the Grateful Dead with Jerry something like, I'm going to say close to 200 times. So for those of you who never saw Jerry Garcia, you missed out. I'm sorry. But you can live vicariously through me. Ticketmaster and Ticketron were 2 different companies. Jonathan, I think I'm older than you, number 1. Was Ticketron only for like Broadway shows? I think I don't know. You're going to have to research this one, Jonathan. Thanks for 441 and 440, but we may have to table this until later. All right. I'm not going to argue about the pronunciation of Mangione because it doesn't end in an I. That's all I'm going to say. If you're from New York and New Jersey or the tri-state area, it's Mangione. That's all I'm going to say. That's all I'm going to say. Well, you know how I love to be validated, right? I love to be validated. I love it when, people out there think I have some sort of TMU law degree or something, and I'm not really a lawyer, and, I don't know what I'm talking about. There's a lot of people out there who think that. But when the pros come in, the real hired guns, like the really experienced guys like Robert Alessi, who's making his debut today on paper, validate everything I said the other day when we went over the Dr. Russell Commonwealth motion, how they want to have this, I call it Daubert. People say Daubert. It depends on where you went to law school and who your professor was. In torts, the torts professor. The Daubert hearing on Dr. Marie Russell. And I said, why are they doing this? She already qualified Dr. Marie Russell as an expert. Is Judge Cannoni going to now overrule herself and say, oh, I really shouldn't have qualified her as an expert? I thought it was ridiculous. Some of you might have thought it was ridiculous too. But guess who else now thinks it's ridiculous? Dun, dun, dun. Robert Alessi, New York attorney extraordinaire, has now opposed this motion regarding the hearing that is supposed to take place on Thursday, where they're supposed to fly Dr. Russell in from California and have her get on the stand again, do a whole nother hearing about her qualifications. And Alessi's clapping back. He's like, yeah, no. How about you already qualified her as an expert? And this isn't really a Daubert hearing that you want. This is really an evidentiary hearing. So no, Judge, here's our opposition. Cancel it. Hello. The young jerks are here. Hello, young jerks. Hello. Hi, Mike. So that's the first thing I want to do with you. I'm going to look at Robert Alessi's motion about why there should be no hearing regarding Dr. Russell. And if you didn't watch that show, I think it was just the other day. I don't even know what day it is. It's hard for me to believe that yesterday was the day that we did the Daniel Penny verdict, that Daniel Penny was found not guilty only yesterday. It feels like a week ago already. We went over the Commonwealth's motion. We went back and rewatched Dr. Marie Russell's voir dire from the first trial that the jury was not present for. That was just the hearing with regard to whether or not she was going to be qualified as an expert. And you remember, because we watched it, Judge Cannoni said, oh, she can testify. She just can't testify about other things other than the dog bites or the alleged dog bites. So we watched it, and then we watched some of Nicole Albert's testimony all about Chloe. That was fun. If you didn't watch that show and you need to catch up on it, go back and watch it. Maybe I'll link it in the video description below. But that's what I said. I said, what is she? She's not gonna just reverse herself. And yeah, it may be a new trial, but yeah, not so much really. Same expert, new trial, but it's the same expert, right? Of course, right. This is hot off the press. Everyone thank Jonathan if you see him in the chat. This is paper number 439. This was just filed this morning at 11 a.m. Look at us. Look at us. We are on the cutting edge, my friends. You know, my mother was listening to me yesterday when she was in the car talking about Daniel Penny, and she said, Melanie, I'm so proud of you. You broke that verdict before anybody else. You broke that verdict before I even got a New York Post notification. I was like, Ma, it's crazy. Oh, I'm wrong. I'm wrong, John Little. No relation to me, but you know, people love to call me out about it. And you guys correct me sometime. It's okay. But thank you. Thank you for thinking I'm always right. Hi, V. Kaser. Thank you for the hearts. YouTube system account says, shout out to Dana Marie from Staten Island. You tracking? Dana Marie, what up, girl? What up, Dana Marie? I have a lot of relatives from Staten Island. They used to call it the Isle of Paradise. The Isle of Paradise. Home of the real Bada Bing, probably. Sarah in Shock and Horror has been here for 5 months, and she's an amazing moderator for my channel. And that's why we have such an amazing channel, is because of my moderators. Thank you, Sarah. Best 5 months ever. Kezchik, thank you so much. Yellow cottage cheese. Italian, every vowel is pronounced. Okay, but not when it's Gione. If it was Gioni, I might agree with you. But when it's Gione, maybe I'm going to say it's regional. Maybe it's regional. You know, my people are from, you know, maybe a different region than your people. Hubert, thank you for being a stable ship in a rocky sea for us locals, Attorney Mel. Thank you, Hubert. Thanks for having the name of my favorite video game from so very long ago. I was really good at the game, Hubert. Thank you for your 5. Doc, but thanks for the 10. In the car all day for the visiting nurses, usually listening on replay. So happy to catch you live. Let me say something. Visiting nurses are the best. You're doing the Lord's work. Thank you for what you do. Anybody who knows how hard it is to find home care knows how hard it is to find home care. So thank you. Thank you for being a visiting nurse, Doc 12, unless you're a Doc 12 that also has visiting nurses traveling with you, in which case, thank you, doctor. And we're so very glad that you're here as well. And thank you for the 10. And if you're in the car all day, please don't text me while you're driving. Thanks. I do find it that I do keep a lot of people company all day. So I like that. You keep me company too. Toby Mama, checking in from the UK. Got my popcorn ready. All right. And Kezchik has been here for 6 months. Wow. You know, it's like, I feel like I only, like literally started memberships maybe a year ago, maybe a little bit less. Did Jonathan get the Commonwealth ARCCA filing too? Oh, yes. Oh, yes. Oh, yes, he did. Oh, yes, he did. KLM. What do you think? He does half a job? Thank you. Thanks for the 5. And also, Izzy, thank you for hanging around for a month. First thing we're going to do is we're going to go to the opposition for the Marie Russell motion. And if you have questions, please kindly save them, because when I am reading to you, which is now going to be a cold read right now because I have not been able to red pen this. So sorry. People are saying you pronounce the E. I'm so sorry to interrupt, or so sorry to correct me, but I don't know. I don't know how you spell your last name. Simone? You're saying it's Simone? You call yourself Simone? All right. I'm not going to say that. I'm not going to say that I stand corrected, because where my people are from, we don't pronounce it that way. Forgione, Forgione, is Forgione. It's not Forgione unless it ends in an I. So I'm going to say it's regional. I'm going to have to go with that, Michelle. Respectfully. Respectfully. So we can stop arguing about the pronunciation. Okay? Okay? Everyone who has a different opinion can have a different opinion. We can all have different opinions on Italian pronunciation, but thank you so very much. I'm on the air. Hold on. But thank you. Okay, let's go. And the people that are asking questions like, do they have any reason to exclude her right now? Let's save the questions till the end because I'm not going to stop reading the document that we haven't read yet to talk about the opinion of the document that we haven't read yet. Okay? Okay? Okay. Sua Sponte, somebody asked for the Venmo. I put it up there in the corner for you because in case you would like to, contribute to like a couple of the college educations that I'm paying for right now. That'll be as always greatly appreciated. Okay, here we go. This is the defendant's motion to the Commonwealth's motion. Defendant's opposition to the Commonwealth's motion. What are you doing? To exclude the testimony of Dr. Marie Russell and request or a Daubert Lanigan hearing. See, like some people say Daubert, some people say Daubert. We can agree to disagree. Now comes the defendant, Karen Reed, and respectfully requests that this honorable court deny the Commonwealth's motion to exclude the expert testimony of Dr. Marie Russell. Number 2, deny the Commonwealth's request for an evidentiary hearing under the standards as set forth in Daubert and Lanigan. And 3, cancel the hearing scheduled for December 12th, 2024, to the extent that it is intended as an evidentiary hearing under Daubert, because the Commonwealth has not made the threshold showing that an evidentiary hearing is required. And this opposition further establishes that no evidentiary hearing is warranted. Commonwealth's motion is an improper and untimely motion for reconsideration of the court's determination during Miss Reed's first trial. How do we know that Robert Alessi is the one who wrote this motion? Well, we know that because the attached affidavit signed by Robert Alessi, but we'll get to that second. The Commonwealth's motion is an improper and untimely motion for reconsideration of the court's determination during Ms. Reed's first trial that Dr. Russell is qualified to offer expert testimony concerning the nature and cause of Mr. O'Keefe's right arm injuries. Oh, yes, it is. It's exactly what it is. This determination was made after a full voir dire hearing, during which the Commonwealth cross-examined Dr. Russell concerning her qualifications and the methodology underlying her expert opinion. The Commonwealth offers no new information in this motion, which it waited to file for over 4 months after this court set a date for a new trial. I'm getting blinded by the light over here a little bit. Okay, that's better. The Commonwealth offers... Oh, I just read that sentence. Okay, the motion should be denied on that basis alone. Right. What's different? What's changed about dog bite technology or dog bite medicine or dog bite, things and stuff, and identifying dog bites? What has changed in the medicine since the last time you qualified Dr. Russell for as an expert? And also, did anything else change? Like, she lost her license or was, convicted of perjury or something? The Commonwealth's renewed challenge of Dr. Russell's qualifications and methodology is also without merit. Dr. Russell is eminently qualified to offer testimony concerning the nature and cause of Mr. O'Keefe's right arm injuries, which, emblematic of the weakness of its motion, the Commonwealth now tries to downplay as minor, in quotes, and, quote, isolated to one area of his forearm, end quote. A review of the photographs of his arm quickly debunks that false assertion. I feel like I'm just going to break from the document for a second to say, I feel like somebody is listening to me. Someone's listening to me. Other than the 3,074 of you that are here right now, this is I pointed this out the other day. Now they're minor and isolated to one area of his forearm. Validation feels good. Dr. Russell has decades of experience as a board-certified emergency medicine physician, treating patients with all manner of injuries, including hundreds of patients with wounds inflicted by dogs. And she's a fellow trained forensic pathologist with decades of experience in that field as well. Got to get my red pen ready because you know this girl loves a red pen. I didn't get to finish redlining it. She has published and edited several peer-reviewed publications concerning the diagnosis, treatment, and identification of dog-induced human wounds, and has been qualified as an expert in numerous state and federal cases in emergency medicine, forensic pathology, and wounds. The pattern recognition and differential diagnosis methodology that Dr. Russell employs to determine the nature and cause of Mr. O'Keefe's wounds is also reliable. Emergency medicine physicians comprise the relevant medical community for dog-induced human wound identification and evaluation. Oh, he's going to say it. He's going to say it. Listen. As a matter of common sense, such physicians are trained to recognize patterns in injuries and ailments to properly diagnose and treat them. Their reliance on experience to recognize injury patterns is inherently reliable and is well supported in the law. Further, the use of pattern recognition to identify such wounds is generally accepted in the medical community. Dog bites and scratches possess certain characteristics that doctors look for to diagnose the cause of a wound and determine the proper treatment. Dr. Russell employed this pattern recognition in opining that Mr. O'Keefe's arm injuries likely were caused by a large dog. Remember in Mr. Brennan's motion, he said that she's not like qualified in veterinary medicine. And we said to ourselves, or I said to you, or to the cosmos, if your child had a dog bite, would you take your child to the veterinarian to treat that dog bite? How many dog bites do veterinarians see? Unless a dog bites another animal, like a dog, and then that animal is taken to the veterinarian. But veterinarians don't typically see human dog bites on humans, right? Common sense. That's all it takes sometimes, my friends. The Commonwealth has presented no competent evidence to call into question Dr. Russell's qualifications or the methodology that Dr. Russell employed in forming her opinions. The Commonwealth has not presented an affidavit from an expert of its own to identify what the Commonwealth believes to be the proper methodology to employ in identifying the cause of Mr. O'Keefe's right arm wounds. It instead relies solely on ipse dixit assertions in an attorney's affidavit. Gonna have to learn some Latin today, my friends. Memorandum of law and the record developed during Ms. Reed's first trial. Given this record, the Commonwealth has not made the threshold showing that an evidentiary hearing is required. Its motion is insufficient on its face, or as Liza Little said, facially insufficient. It's another way of saying the same thing. Insufficient on its face. The Commonwealth's motion should be denied in its entirety. Ipse dixit translates in Latin to he himself said it. According to the legal dictionary website, in legal contexts, it refers to an assertion or statement made by an individual based solely on their own authority without any supporting evidence or proof. You know, you don't really see that term very often in legal writing, but I like it. Ipse dixit, a dogmatic and unproven statement. Let's try and work that into our everyday conversation, right? I mean, recip salaquator, we see that a lot. We see sua sponte. There's a sua sponte in the chat today. Like it. Somebody's going to change their name to Ipse Dixit by the end of this stream. Here's the proper spelling: IPSE Dixit. You know why? Because Robert Alessi doesn't have any Scrivener's errors so far that I can see. And here's the other thing, my friend, ipso facto. Yeah, ipso facto is a good one. Here's the other thing. Not that we're keeping score or anything, but maybe we should keep score. Maybe somebody would like to keep score in the chat. Since Mr. Brennan has come on board, how many motions has he made and how many motions has he lost? And here's what's interesting too, is that Lally, as I recall during the first trial and pretrial, Lally didn't lose a lot of motions, right? We've already lost, well, they, and when I say we, I mean they have already lost so far, the Commonwealth, since the retrial. They've lost the motions for both of the Reeds' cell phones. They lost the motion for ABC, which we're going to see today. And maybe some others that I can't think. Oh, here's Ipsy Dixit. Ipsy Dixit is here. Ipsy, welcome everyone to Ipsy Dixit. First in line with the new name, is owning it. I love it. I love it. And here's the other thing. So they had to go outside and hire this hired gun, right? They hired this hired gun. His name's Hank Brennan. And he's filed a lot of motions. He's also lost a lot of motions, like more motions than I think I've seen Lally lose. I don't know. We'd have to go back and start keeping score. I'm sure somebody's got a spreadsheet out there. But deny is what we're seeing. And they're paying for this, remember. They couldn't have somebody from inside the house of the Norfolk County District Attorney's Office retry this persecution because it was like the hot potato that nobody wanted. So they went outside. They hired Brennan. He's doing it for $250 an hour, as you know. I think my plumber makes more than that. And he's got a cap of $75,000, which isn't even going to get him anywhere near it's not going to get him through his pretrial prep, I'll tell you that right now. But the fact that both of the Reed cell phone motions for Bill and Janet's cell phone motions, both of those motions were lost because his affidavits were facially insufficient, meaning he didn't even address the 4 prongs of Lampron. It's kind of basic. And now, if true, he didn't show what he needed to show in his motion to exclude Dr. Russell. Well, I'm going to have a problem. It's kind of like squandering money at $250 an hour. Hello, Ozzy. Hello. So there's that. When he reaches his limit, Tinkerbell, he's just going to extend his contract. He's going to make a motion to extend his contract or ask whoever's in charge of the money over there to extend his contract, do another, get him to a higher limit. And they did that with Mellow Yellow. They did that with Ken Mello. Do we have proof of life yet on Ken Mello anyway? Ken Mello's been paid something like close to 6 figures to persecute Aiden Carney, right? And now they hired, because Mello is now conflicted, they had to hire Cosgrove. They're paying him. If you live in Norfolk County, you should be outraged that they're spending all your money hiring outside attorneys because they don't have anybody inside who's willing to touch the Karen Reed case. And then they keep having conflicts, so they have to hire outside attorneys to persecute other people. And then, the rubber duck thing. Oh, the Duckgate conspirator. That was all dismissed yesterday. I'm going to do a show on that soon. I'm working on something special for you. But all those felonies were tossed by a judge who has a lot of common sense. So there goes that whole investigation. How much did that whole investigation cost them? That 36-page police report that they did for little teeny weeny rubber duckies. They did more of an investigation on those rubber ducks than they did for the murder of Officer John O'Keefe. Yeah, I'm going to say it out loud. They did. Judge Walsh, thank you. Oh, we have another Ipsy Dixit already. Ipsy Dixit Sherilyn, unless you just added Sherilyn to your name. Yeah, Aussie's been dropping some great videos. If you guys haven't seen them yet, go watch them. Not now, but later. Aussie Insider. She was keeping me busy this morning. What's the old saying Kim says? You get what you pay for? What the duck? The ducks are free. Yeah, the ducks are free. Formerly What the Duckling. Okay. Here's the relevant background. Dr. Russell is a board-certified emergency medicine physician who's been treating patients in the emergency room for 3 decades. Dr. Russell has treated over 500 patients presenting in the ER with dog bites and scratches, among the thousands of patients that she has treated for all manner of injuries. Dr. Russell has also co-authored 2 peer-reviewed articles concerning the nature and treatment of dog-induced human wounds inflicted by law enforcement canines. While a fellow in the Los Angeles County Coroner's Office, Dr. Russell conducted hundreds of autopsies of victims with various injuries, including gunshot and stab wounds, wounds from motor vehicle accidents, and dog-induced wounds. In addition, she's a trained forensic pathologist and is a fellow of the American Academy of Forensic Sciences. She's been qualified as an expert in emergency medicine, forensic pathology, and wounds in numerous cases in federal and state courts. On June 6, 2024, that was during the first trial, the Commonwealth moved to exclude Dr. Russell. The Commonwealth specifically contended that the proposed testimony of Dr. Russell may necessitate a Daubert-Lanigan hearing to assess, among other things, Dr. Russell's qualifications and the reliability of her methodology. On June 18th, 2024, we watched this the other day, the court presided, we re-watched it because we watched it the first time live during trial. The court presided over a voir dire examination of Dr. Russell. At the beginning of the hearing, the court permitted the Commonwealth to question Dr. Russell broadly about both her qualifications as well as the underlying bases for her anticipated opinion. And that is precisely what the Commonwealth proceeded to do. On direct examination at the voir dire hearing, Dr. Russell testified about her extensive experience treating and studying dog-induced human wounds. Dr. Russell next testified about her review of relevant materials in this case, including hospital and autopsy photographs, the autopsy, neuropathology and toxicology reports, grand jury testimony, and emergency room records. Based on her review of these voluminous materials and her vast experience with dog-induced human wounds, Dr. Russell concluded that the injuries to Mr. O'Keefe's right arm Dr. Russell concluded that the injuries to Mr. O'Keefe's right arm were consistent with a large dog attack. In describing how she reached that conclusion, Dr. Russell emphasized the patterns present in the wounds, including, quote, parallel wounds that could have been caused by nails or could have been caused by teeth, and an arch area of teeth marks, end quote. On cross-examination, the Commonwealth's entire line of questioning was focused on attempting to attack her qualifications and the reliability of her opinions, and also her subscription to the Boston Globe. That was a highlight. After the cross-examination concluded, the court noted that the Commonwealth's motion raised Daubert-type concerns and asked whether the Commonwealth was seeking any limitations on the scope of Dr. Russell's testimony. In response, the Commonwealth conceded that the court could permit her to testify as to the injuries that she observed, her work and history in that area, observing prior injuries related to animal attacks, and whatever consistency she believes they may have with that. The Commonwealth also admitted that Dr. Russell is certainly a very experienced emergency room physician, so anything in relation to that, I think it's permissible. In concluding the hearing, the court emphasized its role as the gatekeeper. Oh, remember that? Oh, I see a meme. The gatekeeper. Judge Canoni, the gatekeeper. As to whether she can actually assist the jury, and reserved decision to further consider that question. On June 20th, 2024, the court issued its ruling on the Commonwealth's motion to exclude Dr. Russell. In permitting Dr. Russell to testify on, quote, whether or not the marks on John O'Keefe's arm were the result of an animal attack. The court found that she had specialized knowledge in that field that may assist the jury in this regard. It's the affidavit of Robert J. Alessi, dated December 10th, 2024. In short, the court exercised its gatekeeping function as mandated under Daubert Lanigan in permitting Dr. Russell to testify on the topic of dog-induced human wounds. At trial the next day, the Commonwealth cross-examined Dr. Russell extensively, attempting to challenge her qualifications and the reliability of her opinions. Notably, the Commonwealth did not request that her testimony be stricken or otherwise diminished based on her responses during cross-examination, nor was there a basis to do so. On July 25th, 2024, the court set a date for the start of a new trial. On December 1, 2024, over 4 months later, the Commonwealth filed the instant motion requesting that this court reconsider its finding that Dr. Russell was qualified to render an opinion in the defendant's first trial and that the methodology or theory underlying her opinion was reliable. In support of its motion, the Commonwealth offers 5 pages of legal argument accompanied by an attorney affidavit that merely repeats the same arguments in the motion based on nothing more than the record developed during the first trial. The Commonwealth does not present any conflicting expert testimony or literature to suggest that the pattern recognition methodology that Dr. Russell employed is unreliable. The Commonwealth instead resorts to incorrect statements about and distortions of Dr. Russell's professional qualifications and unsupported ipsy-dixit attorney assertions about the reliability of Dr. Russell's testimony. Oh, I'm so glad he put ipsy-dixit in there twice. It brings me joy. Brings me joy. Dr. Russell has prepared a written report that further elucidates her qualifications, her methodology, and a summary of her opinions. We discuss the report in greater detail below. Argument. Well, before we go to argument, let's go to the chat because there's some things here. Izzy, thank you. Again, David, did you come in again to correct me? The E is pronounced in Italian because that's the Americanized pronunciation. Okay. If you're the expert on Italian pronunciations, I'm going to allow you to pay me $5 to tell me your opinion. Thank you so much for telling me your opinion for $5. Laura, Dr. Russell, woof woof. Are you scared, Massachusetts? Thank you. Thank you, Lemonade KL, for being a member for a month. Love you so much right back. And Joseph Kane for your super sticker. And Joe Ellen for becoming a new member. And Giga Dog Bits, thanks for the 5. Dr. Russell needs to be excluded. She clearly didn't know the difference between gigabytes and gigabits. Well, yeah. I mean, right? Thank you. On top for your super sticker. Joseph Kane, you say Ipsy. I say doodle. Ipsy doodle. Sage, I'm sure Bev will deny this because it's, quote, a new trial, end quote. I don't know. I'm pretty sure that Mr. Counselor Brother Alessi is going to have some case law on this. So let's stay tuned and see. Thank you, Sage. Dagny, thanks for the 5. I love how he's referencing trial timestamps. A not so subtle shot at Brennan for not watching the trial. Well done. Kevin, the Sallyport camera. Why only a Daubert and Dr. Russell? They're afraid. Did they have something to impeach her? Well, that was the whole title of my whole stream the other day, Kevin the Sally Port Camera. You were here, weren't you? Who's afraid of Dr. Russell? Dr. Russell, Dr. Russell. They don't. If they had something to impeach her, if they had a witness, an expert to counter or anything, they would have put it in their motion papers, and they didn't. And that's exactly what our new friend, Robert Alessi, is pointing out here. They have some sort of dog behavioral expert that they've exchanged, and we looked at some of his video that we found on the YouTube, and he's, I think, from the UK, and he talks a lot about owners who don't train their dogs properly, and we watched some of that video together. I know we did. I'm not that crazy yet. Thank you, Kay, for gifting 5 memberships. Kay Willis, the realtor, is here, my friends. For all your real estate needs. Thanks, Kay, for gifting 5 memberships. And to those of you who randomly were selected by YouTube, welcome. I see you. I see you, Tom CPU. You can't hide from me. Hi, Tom. It's like an all-star chat. It's like an all-star chat here today. All right. Moving right along. Laura's taking a red eye tonight. Maybe I'll run into Jackson. Well, he doesn't have to be here till Thursday morning, right? So, and look, they're asking to cancel this hearing, but as we're going to see from one of the other decisions that we're going to look at, she wants them to enter into some sort of a discovery schedule on Thursday. So it's probably going to happen. That date, just whether or not Dr. Russell's going to have to be here or not, is going to be at issue. Oh, Mr. Goodman is here. Hello, Mr. Goodman. Thanks for the breaking news. Now you watch, everyone. See, Mr. and Mrs. Goodman have like a competition. Mrs. Goodman will come in on the Venmo and she'll be like, I got to outdo him. I can't let him outdo me. Thanks, Mr. G. We love the Goodmans here. We love the Goodmans. Okay, I got to full screen it again for myself. And here's Kelly Reed. I mean, really, could we have more of an all-star chat? Hello, Kelly Reed. All right, moving on. The argument goes like this. The court should deny the Commonwealth's request to reconsider its prior order permitting Dr. Russell to testify. I'm like blinding myself over here. I'm like blinded by the light. The court already found that Dr. Russell is qualified to offer expert testimony on the cause of Mr. O'Keefe's arm injuries. As noted, the Commonwealth acknowledges that it is asking the court to reconsider its finding that Dr. Russell is qualified and that her opinions are reliable. Wholly absent from the Commonwealth's motion, however, is any explanation of the standard that the court should apply in deciding whether to revisit and disturb its prior ruling several months after its entry and based on no new evidence or change in the law. That omission is no accident. The proponent of such a motion bears the burden to establish a basis for reconsideration, and the Commonwealth knows that it cannot meet that burden. The Commonwealth instead improperly attempts to shift the burden to Ms. Reed to again prove that Dr. Russell is qualified and that her methodology is reliable. The court should reject that attempt. He's saying, Your Honor, this is a blatant attempt at calling this a motion for something other than really what it is. That's what he's saying in legalese. Where a party moves for reconsideration, the motion may not be a mere rehash of prior arguments and must be made within a reasonable time. Whereas here, a motion to reconsider has nothing new to offer and introduces the same matters previously presented, the court may deny the motion without a hearing. Guess who's coming in with the Massachusetts case law? The New York attorney admitted pro hoc vice. He's got all the Massachusetts case law on that. All of it. A timely motion for reconsideration generally is one that is filed within 30 days of the action the moving party wants reconsidered. Commonwealth v. Claudio from 2020. These self-imposed guardrails on a court's discretion to revisit its prior rulings flow from the truism that a court ordinarily ought to respect and follow its own rulings made earlier in the same case. Judge, you already ruled on this. They've presented you with nothing new since your last ruling. They didn't follow the 30-day rule. And here's a United States Supreme Court case from 2002, in case you need some authority for that. Ellis v. United States. This fundamental principle. Well, it's a First Circuit case. It's a federal case anyway. This fundamental principle protects litigants from the expense and vexation attending or relitigating the same issues, conserves judicial resources, and fosters reliance on judicial action by minimizing the possibility of inconsistent decisions. Measured against these standards, the Commonwealth's motion is an untimely effort without any proper justification to revisit an issue that this court already decided. Can you say, you really, really, really need to chew up my retainer? Nah, just kidding. Preliminarily, the Commonwealth failed to make its motion within a reasonable time. While courts do not inflexibly adhere to the general 30-day period where an interlocutory order is concerned, the motion still must be sought within a reasonable time. And the general 30-day period remains the yardstick in assessing timeliness. I'd like to point out to you as well that Counselor Alessi comes from an international law firm with offices all over the world, probably has a huge staff, and is also offering his services to the Karen Reed defense team pro bono. Pro bono, that is Latin for free. For free. He's doing it for free. Because apparently he feels so strongly about the injustices here. I'm a big fan of his writing so far. Under any measure, the Commonwealth's motion is untimely. Commonwealth filed this motion over 4 months after the court set a date for a new trial and over 5 months after the court issued its ruling permitting Dr. Russell to testify at trial. The Commonwealth has offered no justification for its delay, and there is none. The motion should be denied on untimeliness grounds alone. And here's a Massachusetts appellate court decision that rejected a motion for reconsideration 87 days after entry of the initial order. And this is like over 5 months, roughly 150 days. Here's the precedent, Your Honor. Kind of got to follow it. In addition to being untimely, the Commonwealth's motion fails to present any new evidence or a change in the law that might warrant the court's reconsideration of its prior decision. The motion comprises 5 pages of legal argument that rehash the same issues that the court already decided, and an attorney affidavit that largely repeats those same legal arguments based on no new information. Here's the other thing, my friends. We got a new lawyer on our team is not a good enough reason to make the motion. It's not a good enough reason to say, well, look, we got a new guy. The new guy didn't make the last motion. The old guy made the last motion. The old guy, Lally, the guy who's sitting over here, his posture is not great because he probably feels like he's been emasculated. He made the motion the first time. Now I'm here. I want to make the same motion. It doesn't work that way. The court already fulfilled the gatekeeper role. And that's her That's her own quote. It's the judge's own words. The court already fulfilled the gatekeeper role that Daubert and Lanigan requires in permitting Dr. Russell to testify. At the voir dire, Dr. Russell testified extensively about her decades of experience as a board-certified emergency physician diagnosing and treating all manner of wounds, including hundreds of dog-induced human wounds. Contrary to the revisionist history that the Commonwealth presents, revisionist history, I love it. Dr. Russell's experience is not from 28 years ago and focused on law enforcement canines. Thank you. Thank you for pointing it out, as I so brilliantly pointed out during my last show when I went over his motion initially. Thank you so much. Her experience with dog-induced human injuries spans her entire 30-plus year career as an emergency physician and forensic pathologist, and predominantly concerns wounds caused by civilian dogs, not law enforcement canines. Yeah, it was her papers that were focused on law enforcement canines. On the basis of Dr. Russell's voir dire testimony, the court was satisfied that as an experienced ER doctor who observed, treated, and studied hundreds of dog-induced human wounds, Dr. Russell has specialized knowledge in that field that may assist the jury in assessing whether the marks on John O'Keefe's arm were the result of an animal attack. Notably, the Commonwealth did not disagree with that conclusion at the time. The Commonwealth should not now be permitted to reverse its course. And there's certainly no basis for its request that this court do so. The court correctly found that Dr. Russell was qualified to testify as to the cause of Mr. O'Keefe's arm injuries. Nothing in the Commonwealth's motion supports a contrary conclusion. So basic, so simple, and yet such a foreign concept to the Commonwealth, apparently. Dr. Russell also explained the methodology she used in concluding that Mr. O'Keefe's arm injuries were animal-induced. Citing Lanigan, she based her opinion on the several patterns that she observed in the wounds that were consistent with dog-induced human wounds that she has seen hundreds of times in her career. As discussed below, this pattern recognition methodology is widely accepted in the relevant medical community, as recognized in peer-reviewed literature, showing that dog-induced human wounds possess specific characteristics that enable them to be identified as such. Unsurprisingly, courts routinely permit medical professionals to testify about the nature or cause of a victim's wounds, including dog-induced wounds. See, for example, Commonwealth v. Sullivan, 1984 case, Dunham, which is a federal New York case, Southern District of New York from 2023, finding doctor who personally repaired thousands of wounds and lacerations, including wounds and lacerations. Jonathan is on it like you don't even know. Caused by dog bites, qualified to testify on treatment and characteristics of dog-induced human wounds. Court correctly found that Dr. Russell is qualified to testify as to the cause of Mr. O'Keefe's arm injuries. So this is citing a federal case from New York, very similar fact pattern. As the Commonwealth has offered nothing new to suggest a different conclusion, its motion should be denied without a hearing. Point B, even if this motion was properly presented, Dr. Russell easily meets the requirements of a testifying expert. The Commonwealth's motion should be denied as untimely and improper. But even if the court were to consider the Commonwealth's challenge to Dr. Russell anew, the result is the same. Dr. Russell is eminently qualified to testify about the cause of Mr. O'Keefe's arm injuries, and the pattern recognition methodology she applied in reaching her conclusions is reliable. On a motion to exclude expert testimony, courts consider whether 5 foundational requirements have been met. Okay, so this is what courts need to consider when they're deciding whether or not to exclude the expert testimony. Number 1, that the expert testimony will assist the trier of fact because the information is beyond the common knowledge of jurors. 2, that the witness is qualified as an expert in the relevant area of inquiry. 3, that the expert's opinion is based on facts or data of a type reasonably relied upon by experts to form opinions in the relevant field, which is the medical field. And really, if you're in the comments like with spoilers, you're going to get deleted. You're just going to get deleted. It's so rude. There were people in the comments yesterday when we were doing the verdict on Daniel Penny that literally like seconds ahead of me on Twitter and like had to like put it in the chat. Just don't do it. I'm on top of it. I know what I'm doing. I do this a lot. I'm here for hours at a time. Just don't do it. I already said not to ruin my namaste. Really? We're not even done reading the damn thing yet. Oh. You know what I'm saying, Team Brittany, right? Scott, little cupcake. So rude. Like, why do people feel like they're just like entitled to do that? 4, that the theory underlying the opinion is reliable. And 5, that the theory is applied to the particular facts of the case in a reliable manner. Citing Commonwealth v. Polk. Here, the Commonwealth seeks to exclude Dr. Russell only on the grounds that she's purportedly unqualified to render an opinion and that the methodology she employed is unreliable. The Commonwealth is mistaken on both points. Number 1, Dr. Russell's education, training, experience, and familiarity with dog-induced human wounds qualify her as an expert on the topic. Parties agree that the crucial issue in determining whether a witness is qualified to give an expert opinion. I mean, do you want me to just stop reading? Should I just stop reading? Should I just stop reading? Okay, we'll just trash this and we'll go on to something else. Is that what you want to do? I mean, I could shut off the air conditioning. We could do that too. Got to spoil it for the whole class, really? Parties agree that the crucial issue in determining whether a witness is qualified to give an expert opinion. I mean, maybe I'll just read faster. You can put me on double speed later and it'll sound like I'm like, is whether the witness has sufficient education, training, experience, familiar with the subject matter of the testimony. Oh, and then we're back to Rentala. We discussed Rentala the other day. Dr. Russell overwhelmingly meets these requirements: education, training, experience, and familiarity with the subject matter of her testimony. Dr. Russell's education, training, and experience qualify her as an expert in identifying wounds and injuries in humans resulting from an animal attack. As demonstrated, Dr. Russell is a board-certified emergency medical doctor with decades of experience. Throughout that period, she saw and treated virtually every type of wound, including hundreds of wounds resulting from dog attacks. Beyond that, she's trained in forensic and anatomic pathology. She's conducted over 500 autopsies, including an autopsy of a child who was killed after being attacked by civilian dogs. She also has authored peer-reviewed articles on the diagnosis and treatment of dog bites in the emergency room, including an article that analyzed 700 dog bite cases. And she edited a peer-review emergency medicine publication discussing identification of dog bite wounds. Dr. Russell has precisely the qualifications to opine on whether an injury to the human body was caused by an animal attack. The Commonwealth grossly misrepresents Dr. Russell's experience, asserting that most of Dr. Russell's canine experience was from 28 years ago and focused on law enforcement canines. No part of that statement is true. Dr. Russell's experience with dog-induced human wounds spans her entire 30-plus year career as an emergency medicine physician, and predominantly concerns civilian dogs in the community. That Dr. Russell also treated and wrote peer-reviewed articles about law enforcement dog bites only bolsters her experience. She's seen both types of injuries and knows the differences between them. Commonwealth further attempts to criticize Dr. Russell for being a trained emergency room physician as opposed to a professional in the field of canine bites or claw marks, veterinary medical science. That was laughable. We did have a good laugh over that the other day. Because, when you get bitten by a dog or your kid gets bitten by a dog, that's where you go, to the veterinarian to stitch up your kid's wounds, right? Forensic odontology or canine behavior. That was laughable. Even is going to get an arrow. This assertion is mistaken on several levels. Thank you for pointing that out. First, emergency medicine physicians with Dr. Russell's experience are best positioned to address the questions at hand, or the question at hand. Second, the Commonwealth does not define the field of canine bites or claw marks or explain how emergency medicine physician who has treated hundreds of dog-induced human wounds and authored and edited peer-reviewed publications on the subject would not be within it. Third, the Commonwealth does not explain why a veterinarian, forensic odontologist, or person trained in canine behavior would be more qualified than Dr. Russell to opine on this topic. It is common sense that when people get bit by a dog or other large animal, they go to the emergency department. Praise be. They don't go to a veterinarian, they don't go to a forensic odontologist, and they don't go to a so-called canine behavior person. Just said that. Fourth, these incorrect arguments improperly invite the court to weigh Dr. Russell's qualifications against those of unspecified individuals with different training. Again, talking about Rintala. That was the paint drying expert. Dr. Russell, therefore, is resoundingly qualified. Indeed, it is hard to imagine a medical doctor other than Dr. Russell more qualified in the area of dog-induced human wounds, right? And if the Commonwealth had one, they would have exchanged that expert already, but they don't. 2, Dr. Russell's pattern recognition methodology is reliable. Brittany's getting upset. The Commonwealth mischaracterizes the methodology that Dr. Russell employed in forming her opinions and arguing that it is unreliable. This is point number 2. Thank you, Justin Green, or Justin Green via Cash App. Appreciate you. The Commonwealth's conclusory and unsupported analysis is wrong at every step. Well, if nothing else, our friend is building an incredible appellate record. Under Daubert Lanigan, the judge acting as gatekeeper is responsible for making a preliminary assessment whether the theory or methodology underlying the proposed testimony is sufficiently reliable to reach the trier of fact. In making that assessment, the court may consider whether the scientific theory or process, 1, has been generally accepted in the relevant scientific community, 2, has been or can be subjected to testing, 3, has been subjected to peer review and publication, 4, has an unacceptably high known or potential rate of error, and 5, is governed by recognized standards. These factors are non-exclusive, and courts recognize the potential need to consider other factors depending on the nature of the expert testimony. For instance, a judge may also look to her own common sense as well as as well as the depth and quality of the proffered expert's education, training, experience, and appearance in other courts to determine reliability. Conversely, a court need not consider all 5 factors to permit the expert's testimony. It has long been recognized that reliability can be established by general acceptance alone without regard to the other Daubert-Lanigan factors. Under any mode of analysis, the pattern recognition methodology that Dr. Russell employed in forming her opinion is reliable. First, based purely on common sense, as if anybody involved in this case has any ducking common sense. I mean, that's a high bar. That is a high bar. It's not a sidebar. It's a high bar to say that anybody involved in this case has any common sense. Because we're here. We're in the upside down. We're in the twilight zone. Members, please show off your emojis. Give me some Twilight Zone emojis. Give me some solo cup emojis. Give me some leaf blower emojis, some puffy jacket emojis. Because the duckin' Canton PD doesn't have any common sense when they collect evidence in duckin' solo cups from the guy across the street who just happens to be, wait for it, the acting chief of police of the Canton Police Department, Tom Kelleher. What? What? Canton PD certainly doesn't have any common sense when they tell Sergeant Good to shoot on over to his house and get his leaf blower out of his garage and come on back, and then hands it to Gallagher, who then starts blowing away the layers of snow to see if they can come up with any red pieces of taillight, which they didn't find, by the way. And the Canton Police Department certainly doesn't have any common sense when they, fail to do the million other things that they failed to do in the investigation of a dead brother in blue. I'm getting mad. Now I'm getting mad. My namaste is duck and gone right now. Based purely on common sense and in consideration of Dr. Russell's extensive experience studying, diagnosing, and treating dog-induced wounds, Dr. Russell's use of pattern recognition to determine whether a particular wound was caused by a dog is inherently reliable. Citing a case called Goodman. Oh, look, Goodmans, you're in a case. Goodmans, you made a case in the Massachusetts Appellate Court. Common sense dictates that when a person is attacked by a dog and needs medical treatment, it is likely that the person will go to the emergency department to seek immediate treatment. Emergency medicine physicians like Dr. Russell, thus, are the medical professionals most likely to repeatedly observe dog-induced human wounds and identify consistent patterns in the wounds, as Dr. Russell's own experience shows. In addition to her real-world experience diagnosing and treating dog-induced wounds, Dr. Russell has studied these wounds to understand the key features that distinguish them from other types of wounds, such as arch patterns indicative of the front part of the animal's jaw, parallel injuries indicative of claw marks, and puncture wounds indicative of canine teeth penetrating the skin. And she can distinguish many human wounds induced by a canine dog from those inflicted by civilian dogs. Her experience with both is tremendous. Contrary to the Commonwealth's contention, Dr. Russell's experience with dog-induced wounds is not merely anecdotal. They did say that, didn't they? Oh, yes, they did. It is medically based, extensive, and specific. Dr. Russell directly applied her extensive training, knowledge, and experience in reviewing Mr. O'Keefe's medical records, autopsy report, and photographs of his arm. The recent decision in Dunham v. Lobello, Southern District of New York, from just April of 2023, is instructive. There, the court permitted a physician who has treated many dog bite victims to testify about the nature and treatment of the dog-inflicted wounds of the plaintiff. Yes, this may have been a civil case, Dunham v. Lobello, because that is where most dog bite experts would testify in a civil case. Because medical examiners don't see a whole lot of dog bites either. See, because most people don't die from dog bite injuries. So there's that. The defendants argued, just as the Commonwealth does here, that his testimony was unreliable because his methodology was based on his experience treating such wounds. And they're talking about this Dunham v. Lobello. The court disagreed, finding that his experience repairing wounds and lacerations caused by dog bites qualified him to testify about such wounds, including their presentation. The court also rejected the defendant's challenge to this methodology, which involved the doctor's view of the presentation of plaintiff's scars and a review of pertinent medical records on the grounds that the defendant's arguments went to weight, not admissibility. The same result follows here. The pattern recognition methodology that Dr. Russell used in studying Mr. O'Keefe's arm injuries is reliable as a matter of common sense. And the Commonwealth attempted challenges to that methodology all go to weight, not admissibility. It's interesting to point out here, too, that in this civil case of Dunham v. Lobello, that expert who was allowed to testify that they were dog bites did not see the fresh wounds. He saw the scars, plaintiff's scars, and the medical records. Doesn't even say that he saw photographs of the initial wounds, unless they just didn't address it. I don't know. Second, Dr. Russell's pattern recognition methodology is generally accepted in the medical community and therefore is reliable on that basis alone. As the literature cited in Dr. Russell's expert report shows, dog-induced injuries possess key features that make them identifiable to a reasonable degree of medical certainty. Oh, remember we watched the voir dire and the judge shamed her about not knowing the magic words. Yeah, it's the standard is a reasonable degree of medical certainty. Okay, Your Honor. She's a doctor, not a lawyer. Want to cut her a little slack? Because the question to her on direct examination from her highly skilled attorney is going to be, Doctor, do you have an opinion do you have an opinion based on a reasonable degree of medical certainty? And she'll say, yes, I do. And doctor, what is that opinion? And she will give her opinion. You didn't need to shame her because she didn't say the magic words to you outside the presence of the jury during a voir dire hearing, during which, by the way, you said you ruled already that she was eminently qualified. Certain dog-induced wounds, like the ones Mr. O'Keefe sustained, are so distinctive or characteristic that they are specific to a given source. Quote, tissue defects and puncture wounds presenting as round holes displayed in an arch, particularly when accompanied by claw marks, recognizable by superficial linear abrasions ranged parallel to each other, are highly characteristic of wounds induced by dogs. Given that this pattern recognition methodology has been recognized and accepted for a substantial number of years, it meets the standard for general acceptance and is reliable solely on that basis. In fact, the medical examiner for the Commonwealth herself applied a pattern recognition methodology in concluding that Mr. O'Keefe's arm injuries had some sort of pattern into it and described them as pattern abrasions, even testifying that they could have been caused by an animal claw. Finally, though the court need not reach the other Daubert-Lanigan factors to find Dr. Russell's pattern recognition methodology reliable, those factors also favor a finding of reliability. The methodology has been subject to peer review and publication, as the literature shows that the dog-induced human wounds have unique characteristics that enable their identification through pattern recognition. For the same reason, this pattern recognition methodology is governed by recognized standards. The unique features of canine dentition result in unique patterns in dog-induced human wounds. The methodology also does not have an unacceptably high known or potential rate of error. And that is citing another Massachusetts case. Any potential error rate is low given the distinct pattern left by dog-induced human wounds, and the Commonwealth presents no contrary evidence. Finally, the methodology can be tested by comparing dog-induced human wounds to wounds attributed to other causes, precisely what Dr. Russell has done in her career, and the same analysis that the literature endorses. For each of these reasons, Dr. Russell's pattern recognition methodology is reliable. Commonwealth's legal-only assertions to the contrary are incorrect, unsupported, and at best are again an improper invitation to the court to weigh the evidence rather than fulfill its limited role as gatekeeper. The Commonwealth is free to test its unsupported case narrative that Mr. O'Keefe's arm injuries were caused by something other than an animal attack on cross-examination at trial, but it may not prevent Ms. Reed from presenting qualified and reliable evidence that contradicts its hypothesis. 2. The Commonwealth has not shown that an evidentiary hearing is required. No evidentiary hearing is required because the court already heard and denied the Commonwealth's prior challenge, and the Commonwealth has presented no new evidence, such as an affidavit from an expert of its own or relevant medical literature in conflict with Dr. Russell's anticipated testimony. And here's a case from the Massachusetts Appellate Court that says no hearing is required where the court already decided Daubert-Lanigan motion before the first trial. I mean, if that's not completely on point, then I don't know what the duck is. Moreover, the report of Dr. Russell demonstrates that an evidentiary hearing is not required. Consequently, no evidentiary hearing should be convened to assess Dr. Russell's qualifications or the reliability of her testimony, both of which are well established in the current record. Conclusion, for the reasons above, Ms. Reed respectfully requests that this honorable court, number one, deny the Commonwealth's motion to exclude the expert testimony of Dr. Marie Russell, deny the Commonwealth's request for an evidentiary hearing, and three, cancel the hearing for December 12th to the extent it is intended as an evidentiary hearing under Daubert Lanigan. XOXO, Robert Alessi, Pro Hoc Vice, from a really, really, really big white shoe law firm at 1251 Avenue Americas, which coincidentally is not so far from where the United Healthcare CEO was gunned down as such last week by Luigi. We're just going to call him Luigi since we're fighting over the pronunciation of his last name. And there's that. XOXO. Also, Alan Jackson. And also, Elizabeth Little. And also, we cannot forget Misty and Eddie and Ian Henchy, all signing off on this motion dated, what's today? Today's the 10th, right? Right? It's the 10th, right? Okay. It's the 10th. It is. Tick, tick, boom. Boom, shaka, laka, laka, laka. Okay, let's go to the chat for a minute, shall we? But you know what? Before we do that, I'm just going to take a quick little time out and have a drink, because sometimes when I'm drinking my iced coffee, people complain that they don't like me swallowing into my mic. So you know what? I'm going to turn off my mic. I'm going to go off the screen for 1 minute, but I'll be right back. Bye-bye. Hang on. Oh, you know what? Should I put up the little "I'll be right back" sign so that I don't swallow into the mic and annoy someone today? I'll be right back. And of course, while we were reading that motion, which some people could not keep to themselves, despite the fact that I'm ducking on it, always on it, that motion was denied. So there's no sense in me reading the next part of that motion to you, because in record speed, Judge Cannoni has denied this motion in scribble scrabble at the bottom of document number 439, which we just read together, which says, denied. The court intends to hold an evidentiary hearing on the Commonwealth's motion to exclude based on Daubert and Lanigan. XOXO, Beverly with Justin L.Y., Cannoni. So there's that. Thank you, Andrea. Yeah, some people just couldn't keep it to themselves and they had to spoil the chat. So I'm like, all right, well, why should I keep reading? Why should I keep reading? Everyone knows what's going to happen now. It's like you go to a movie with somebody and they tell you what the ending is going to be. So there's that. I can't believe that she denied this. This is beyond me. Have no idea. It's a freak off is what it is. Thanks, Archangel. That's what it is. It's a freak off right now. Hold on, I gotta spray my throat. Give me a second. There's that. Yeah, maybe, Carrie, maybe. Maybe she's big mad for being called out. I mean, the case law is abundantly clear. She has already ruled that that Dr. Russell is qualified as an expert. There has been nothing new offered from the Commonwealth. There has been no change in the law. It is well beyond the 30-day period with which to file a motion for reconsideration. And so there's that. This is insane. Yep. In record time. Let's see. This motion was filed at, what's the timestamp on here? 11 o'clock. It is now 3:06. And this was sent to me at 26 minutes ago. Lightning speed. Because we're going to fly Dr. Russell out here. We're just going to keep spending the money of the defense. There's that. Denied. Sorry, but we're doing it. We're doing all the things and stuff. You're going to fly Dr. Russell in, even though there are no grounds for this whatsoever. But as we are in the upside down and the twilight zone, I guess she couldn't give Hank Brennan too many losses in a row. Think that's it? What do you think? I mean, thanks, Peaches, for becoming a new member. Thank you to Mids Girl for being here for 6 months. Don't mess with Brother Alessi. Love you, Mel. Well, Mids, this must have been before. Either you didn't see the spoiler in the chat, or we thought he was going to win, and he should have. He should have, but who cares? Because quite frankly, there's no way in the Traveling Mary, for the love of the traveling, there's no way in the love of the Traveling Mary that she could ever be excluded as an expert. Unless the upside down has somehow turned even more upside down. Is that possible? Is it possible for the upside down to be more upside down than just upside down? Thanks, Mod Squad. Bev should say, I wasn't wrong, Mr. Brennan. I refuse to say I was. I'm not afraid of ducks, and I'm not afraid of you. Yeah. Thank you for tuning in from Canada. AJ's Red Eye Pilot, thanks for the 20, says, these people are grasping at straws. How on earth was Trooper Paul allowed to go on and on without any sort of certification in anything? Didn't he take such of a, didn't he take like some courses and like some Zoom classes and kinematics that he could barely even pronounce kinematics? Michelle, can the defense get Garrett Wing? I don't know. Who knows what the judge is going to allow? I want a Daubert hearing on the expert that they actually turned over. That guy, get that guy in. What is he going to testify about? Because nobody knows where Chloe is. How can he testify about Chloe and Chloe's training if nobody knows where Chloe is? Has he met Chloe? Has he had a session with Chloe? Because I'd like to know that. Yeah, thank you, Donna. Donna sent a Venmo and she says, we want Chloe for evidence. They said they know where Chloe is, so produce her. Thank you, Joseph, for gifting 2 memberships, 3 memberships, plus 5. That's 8 memberships from Joseph. And to all 8 of you who were randomly gifted by YouTube. Thank you. And then look, Hanky Zipsy Dixit comes in with the Canadian Deuce. Thank you. Thank you, Joseph Kane. Edward, thanks for the 5. I hope they use this hearing, if it goes forward, as argument that Dr. Russell should not be restricted in testimony the way Canoni did in the first trial. And that's what I said as well the other day, because remember, she, if you weren't here the other day when we talked about her voir dire, she also not only has seen hundreds, if not over 1,000 dog bite patients, she's also seen and done autopsies on several hundred pedestrian versus motor vehicle fatalities. That's what I said the other day. Okay. You want to do a hearing? Okay. Now let's say she's not going to let's also qualify her to testify about pedestrian versus car injuries, to say these were absolutely not, there are no injuries indicating that John O'Keefe was hit by a car. I agree with you. I agree. He didn't get into it in this motion. And I don't know what her report says either, because they did not, I don't think there was a report. I don't have the exhibits that were attached to this. So there's no report that we can see to see whether her opinions about that were in there. So there's that. No, please don't send me any pictures of your dog bites. To everyone out there who has been sending me pictures of their dog bites, no, please don't. I can't unsee them once you send them to me, and I don't need to see them. I believe that you've been bitten by a dog, and I believe it looks very similar to Officer John O'Keefe's dog bites. So please don't. No, thank you. Thank you for the Canadian dues, but no, thank you to the dog bite pictures. People who send me pictures and graphic pictures and links to things, I don't open them. I'm not going to open them. So please don't. Thank you. People, Marcy, Scuddy Stain, thanks for the 10. Isn't it ironic, don't you think, that the Commonwealth is questioning Karen's expert witnesses, but the Commonwealth can bring any inarticulate, witless wonder on the stand to speak in circles, and it's supposed to be okay? Yeah, it is. It's way ironic. Way ironic. Yeah, every day that comes in here is like a new day of just wonderment. It's wonderment. It's crazy. 13 Flags, thanks for becoming a member. Spanky Hanky, thanks for the 5. I'm singing to my dog. Who's afraid of the big bad wolf? Big bad wolf. Big bad wolf. Thank you. Look at YouTube system account. Wants to know if I'm single. Are you part of the algorithm? I'm the worst wife ever. No, I'm just kidding. Thank you. I guess that's a compliment. Thank you so much for the 5, for just wanting to ask me a question and send that message. Abuela Pinky, thanks for the 20. Feel the need to compete with the lovely Goodmans. I love you. Oh, thank you. I love you too, Abuela. Abuela, thank you so much. Muchas gracias. Letteros by Bettero. With all the hatred and vitriol going on, the other social media platforms, this channel has a way of always bringing the Free Karen read movement together like no other. Thank you, Melma's in chat. Thank you. I had the namaste when we started going, and that was, not so long ago. What time did we go? What time is go time today? 1:45? I never know, because it's different every time. Yeah, thank you. Thank you so much. Yeah, because I'm not feeding it then. That's why people get timed out, and then they whine, and then they try and send me private messages like, "Why did your mods time me out? First, why did you time me out? What?" Okay, I'm not dealing with the childish antics of people coming in here trying to disrupt the bubble that we live in here and be mean to people. Nobody's coming in here to burst my bubble. This is my platform. I have control over it. Why did you time me out? First of all, I don't do anything. I'm talking to you for hours at a time. I have moderators that I trust implicitly to make those decisions. And trust me, they usually give you a warning before they time you out. And second of all, if you were timed out, it's because you were nasty or you said something gross or something such as like that. It's just like tough. Thank you. Thank you, MGHAZ, for the 20, and who also loves the mods. I know. They're amazing. Is there any way possible to have that? No, Brenda, they made that motion once before the first trial to have her recuse herself because of alleged personal ties between allegedly herself and some of the witnesses. And in fact, several things were shown. I have a whole entire pre-trial playlist for this case. And if you're interested, you can go back and watch that hearing with, or that show that I did on that. It was very interesting. She denied it. And so at this point, could they make that motion again? I guess, right? New trial, new rules, new everything. Oh, we're also going to look at, she did agree to delay the trial. So there's that. We're going to look at that as well. So let me just pull that up for you. Because, we like to be accurate and all things like that. So she did allow the motion for the adjournment of the trial, but it doesn't say that it's exactly going to be April 1st. What it says is allowed. This was on the motion, paper number 402 was the Commonwealth and Defense joint motion to continue the trial date. And note here that was made on November 4th. And this was just decided like yesterday, which would have been December 9th. All it says is allowed. The parties are to jointly propose a scheduling order for the court to consider on December 12th. So yeah, this was signed yesterday. So the hearing is still going to take place on the 10th because she's already denied in fastest fashion ever the motion to not have to have the Daubert hearing on Dr. Marie Russell. I keep removing the wrong thing. Okay, so that's something else I wanted to go over with you because that broke yesterday and we haven't covered it yet. I mean, the one thing that I wanted to break to you was the denial in ultra fast speed of that motion that I was in the process of reading. And then like people thought it was like, they had to be the first one to tell you all in the chat that it was already denied. Susan's outraged. Frodenella says that a spicy melon is my spirit animal. I'll allow it. Lois Lane, hi. Thanks for being a member for 4 months. How does Bev even crab walk the halls of justice? Oh boy. You know who's not happy? Auntie Deb is not happy. Don't bring that up, Lois. Let's not talk about that. But thank you. I don't know. I don't even know where that whole thing came from, that whole crab walk. I don't even know. I don't know. Don't tell me. Don't tell me. Gail Taylor, slurp that coffee to your heart's content. Your time, your show. Oh, thanks, Gail. It's coffee talk. Coffee talk. Remember coffee talk from Zion Live was coffee talk. Come on, let's have coffee talk. We're gonna have coffee talk. Somebody did point out to me that there was like some there's a name of this disorder that people have. It begins with an A, I want to say. Yeah, I do have the Commonwealth motion for reciprocal discovery. I'm going to read that next. Thank you. Thank you. It's Marie. There's a name for that. People have this like coffee talk. They have this disorder that like certain like sounds really annoy them, like slurping and chewing and such things like that. If I don't know the name of it. KLM says that he took a 2-hour class. Frodanella, thank you for your super sticker. Mardella, Roland, thank you for becoming a new member. Hi, Loudmouse. Hank's going to say it's because 1, she retired a number of years, but 2, it's because she's retired a number of years, but 2, he's going to question whether or not she's geriatrically sound-minded. Yeah, a lot of people were thinking like age discrimination. Oh, it's called misophonia, M-I-S-O, phonia. Yeah. Okay. All right. I learned something because that was something I'd never heard of before. Like that thing. One of my kids, one of the 5, had that. Like the tags. Found the tags to be very itchy on the back of all the clothing. I had it like back in the days before they didn't make tags on clothing. Before they started stamping things on clothing instead of like I had to cut out all the tags. That there's a name for that as well. I'm reminding you to stay hydrated. I have the motions, you guys. I have them. Thank you. We're collaborative, but we're on it also. We're also on it. So, let me just download them. Can only do one thing at a time. All right, one of them is 3 pages, and one of them is 7 pages. Oh, because there's an opposition to it as well. An opposition to the reciprocal discovery from the defense. All right, since this one's only 3 pages and somebody asked for it, we'll read this one first before shuffling back to Dr. Russell. We're going to pivot for a second. This is regarding ARCCA. Just filed at 12:50 today. The other one filed at the same time, it looks like, or stamped and docketed around the same time. And because Jonathan is amazing. No, I'm not a cupcake. That's right. I can't please everyone. I'm not a cupcake. See? Says it right over there somewhere. I don't know. The screen is inverted. It's like, you can't make everyone happy. You're not a cupcake. Nope. Please do not send me your dog bite pictures. I saw that somebody just sent me an email with their dog, with something about their dog bite. Trust me, I believe you. I've handled many a dog bite case, and I've handled many. I've seen them. I've seen the pictures. I don't need to see them. I will not open them. I will not look at them. Something's up with YouTube. Can you guys still see me? Because when I'm trying to pull it up on my phone, it's like it's not coming up on my phone. So I can't watch the chat on my phone right now. What? All right, there it is. I'm back. I'm back for myself. Thank you. Okay. Here is paper number. I mean, there's so many creators who don't ever even look at the chat or address the chat ever. Maybe I should just be one of those people. I think maybe I'm paying too much attention to the chat, and I should just not even look at it ever until and only if people like give me super chats, and then I look at them all at the end. There's a lot of people that do that. Here's this is paper number 442. This is the Commonwealth's motion for reciprocal discovery pertaining to employees of ARCCA. And this was filed today. Got to get my red pen ready because this is a cold read. Wait, I just got to. Well, I can see the number on my screen. You can't see it because the Venmo's covering it up. But trust me when I tell you this is paper 442. This is the Commonwealth's motion for reciprocal discovery pertaining to employees of ARCCA. Commonwealth moves pursuant to Massachusetts Rule 14. That's the automatic disclosure rule, automatic discovery, automatic disclosure. Things you just have to turn over. That the defendant produced reciprocal discovery pertaining to employees of ARCCA, including but not limited to Daniel Wolf and Andrew Rentschler, aka Crash Daddies. He doesn't say that, but I know that that's the way that you guys refer to them. As experts potentially to be called by the defendant at her second trial, the Commonwealth is entitled to proper and complete discovery pursuant to the defendant's discovery obligations under Massachusetts Rule 14. Massachusetts Rule 14 provides for an automatic exchange of discovery regarding intended expert opinion evidence. The Commonwealth requests the defendant produce the following materials. Number one, a complete statement of all opinions to be expressed by he is a doctor actually, by Daniel Wolf and Andrew Rentschler, and the basis and reasons for each opinion. Number two, all notes, reports, and materials relied upon either witness, just say relied upon by either witness. Remember, this is a Commonwealth filing. For reviewing this specific case, request for materials is not limited to the expert's report. The Commonwealth is requesting all materials relied upon in review, even if the materials are not part of the expert's report or opinion at trial. Three, a copy of all materials provided to ARCCA LLC, Daniel Wolf, Andrew Rentschler, or any representative of the U.S. Attorney's Office by any member of the defense team or by the U.S. Attorney's Office. The request includes all materials, including written, documentary, video, witness statements, and witnesses produced. I don't think that they've got standing. Karen Reed's defense team does not have standing to turn over to the Commonwealth the stuff that the U.S. Attorney's Office turned over, and who even knows that they even have possession of it? That's kind of like an improper demand. Yep, says John Courtney. Yep. He said it, so I didn't have to. Fishing for federal information, fishing. Deep sea fishing. Fishing for tuna and marlin right now. So if you're going to ask for this stuff, does that mean we're going to be allowed to talk about the federal investigation in the next trial? Because, shield and sword, right? Shield and sword. 4, all materials provided to either witness after the conclusion of the defendant's first trial. Maybe they didn't give him anything, but they can say that. 5, describe and produce any exhibits to be used as a summary of or support of the opinion for the opinion. 6, describe all compensation paid to either expert for all work done regarding this case, including case preparation, testimony, travel, and expenses. Okay, paid by who? I don't know that. Karen Reed's attorneys have the detailed billing records from the Department of Justice or the U.S. Attorney's Office. Because remember, they were hired by the FBI. These were biomechanical engineers who were hired by the FBI to determine whether or not Officer John O'Keefe was hit by a car. Their conclusion was a car did not hit Officer John O'Keefe, and Officer John O'Keefe was not hit by a car because, physics. So, yeah, right, Carrie. Exactly. He hasn't even watched the last trial yet. You think he read over 3,000 pages released already? Around the world says you can tell almost everything about someone by the way they treat their dog. They call their dog It. You know it. They call Chloe It. And what does that tell us about Doug Benefield? I agree with you. I agree with you. Thanks, Team Brittany, for thanking Cat. It is hard to tag Cat because of those emojis that are in the name of Cat Randall. I know who you're talking about. 13 Flags says Brennan came out with a whole pot of biscotti. That's a good one, Laura. I'm just going to put it up there and let everyone read it for themselves. Because then Peachy says, oh, snap. Provide any contracts, agreements, or documents relative to Daniel Wolf, Andrew Rentschler, and ARCCA discussing compensation relative to this case. Okay, well, if they don't have the stuff, whatever. I mean, look, all of this stuff is discoverable, how much they're getting paid, their contracts, what they've provided them to review. But Karen Reed's defense team is not going to be in possession of the stuff that the U.S. Attorney's Office gave them or paid them. Provide all written communication, including emails and text messages between any member of the defense team and employees of ARCCA. I don't know that that's discoverable. That could be considered attorney work product. I'm just saying. Provide copies of all testing, or does that not? Do we not have attorney work product in Massachusetts? Where are my Massachusetts attorneys and paralegals? Is there no such thing as attorney work product in Massachusetts? Like there's no such thing as journalistic shield or journalistic privilege? What happened in number 8? Oh, Ann H, I love you. Yeah, so remember how the last document that we read from the Commonwealth said 789, 789. Like here, there's number 7. Now we have to do this on every document, Ann. All right, let's see. 1, 2, 3, 4, 5, 6, 7, 9. You know what happens? 7, 8, 9. Seven and 9, 8, 8. It would be shameful if it wasn't so funny. Nobody proofreads. What they need to hire instead of a special assistant district attorney is a proofreader, an editor, let's say. I don't know. Gretchen Voss might be looking for a job soon. Considering like being a reporter is not something she's going to be able to do for very long after she gets up on the stand. And because there's no journalistic privilege and because nobody's going to ever want to talk to her again because she can't actually keep anybody's, anything off the record. Nobody's going to, I feel, I'm not going to tell you how I feel. Just yeah, I think so. The Commonwealth is still using a word processor in lieu of MS Word. Do you know how long it took me to get away from WordPerfect? Like WordPerfect was the go-to for legal documents for like decades. And they were like, we got to change to MS Word. I'm like, no, we don't. How are we going to change everything that we've had for decades in WordPerfect all of a sudden over to MS? Like it just fought that. Just like I fought like giving up my BlackBerry. Like they had to pry my BlackBerry from my cold, stiff hands. I did not want to get rid of that BlackBerry. Somebody said the 8 is in Higgins' Jeep with all the rubber ducks. 8 is the fan. 8 is with Chloe in Vermont. Another YouTuber breaks the Chloe album. 8 was rehomed. Oh, yes, I think that's what it is. Team Brittany. It has something to do with the magic 8 ball. Where's my magic 8 ball? I don't have it. All signs point to yes. Remember the magic 8 ball? So 7, 8, 9, 7 to 9, and then we go to 10. Provide copies of all testing not previously disclosed, including crash tests, video reenactments, and any other testing materials and results, regardless of whether the witness will testify to the information at trial. Do you think the ARCCA guys were provided with Yellow Cottage Cheese's video? The reenactment? Do you think they were provided with that reenactment video of someone who looks like he's from The Sims leaning over into the road to pick up a martini glass? And then his head gets whacked by the wrong side of the wrong vehicle. I wonder if they gave them that. I mean, what? Jeff thought that was funny. I made one person laugh today. Oh no, there's a couple of you. There's a couple of you laughing in there. Sometimes you gotta laugh, Cheech, loud, flower, Carol. Otherwise, we're just gonna cry. John Monagle. Can the defense file a motion demanding the Commonwealth turn over bullet point 8? That's what I think we should. We should demand all of the missing bullet points. I mean, including, but not limited to, so many other things that are just revealed themselves. Just revealed themselves. 11, provide all written communications, including emails and text messages between the U.S. Attorney's Office and employees of ARCCA. Really? When we get to the end of this document, we're going to see whether or not Hank Brennan, because we know he's got problems with service, right? Whether he properly served this upon the United States Attorney's Office. So, there's that. Does he not? He really doesn't want to go read those 3,074 pages, right? He just doesn't want to go read them. He's like, you give them to me. "12, provide all communications between the U.S. Attorney's Office and any member of the defense team as it pertains to the expert testimony in this case, including dates and substance of phone calls, copies of any written correspondence, dates of any strategy meetings, and list of materials received from the U.S. Attorney's Office." Well, see, here's the thing, Mr. Brennan. The U.S. Attorney's Office gave you and them everything at the same time. Do you think they're going behind your back and teaming up on you? Do you think they're double teaming you? Do you think that's what this is about here? He's got all this stuff. Ipsy Dixit. Provide a copy of all written requests that have been made by the defense team pursuant to 28 CFR 2E regulations relative to either expert or ARCCA, Inc. Wait, is that proper numbering? Are we 10, 11, 12, 13? Okay. Massachusetts Rule of Criminal Procedure 14 demands reciprocal and expert discovery. If the defense intends to call either Daniel Wolf and or Andrew Rentschler as an expert witness at trial, they bear the obligation of Rule 14 discovery. As the proponent of the witnesses, the Commonwealth is entitled to adequate discovery to prepare examination of witnesses. Yes, Shirley. Yes, they did. Yes. Didn't the defense say that they never spoke to the crash daddies before trial at all? Yes, they did. They said that. They did. But, they may have spoken to him since then. XOXO, Hank Brennan, Adam Lally, Laura McLaughlin. It's dated December 5th, but it just hit the docket today, and I don't see that he served the U.S. Attorney's Office with this. But, there's no affidavit of service here, so there's that. I think that if Mr. Alessi, well, let's see, this is dated the 5th. I mean, if Alessi has a copy of this, I don't know if he spit his coffee out when he was reading it or what. He was laughing so hard. What are we doing? AG's Red Eye Pilot says, damn, this guy's out of control. This is his normal defense role showing. Oop, you're doing that. It's inexperience. Your inexperience is showing, sir. Please tuck it in. I don't know. Sherry or Cherie. John O'Keefe has not been hit by a car. A car did not hit John O'Keefe. Thank you. Oops. My phone thinks I said something else, that S word. Thank you. And in your career, have I seen judge bias like this? The judges have a lot of discretion. So, of course, you always think the judge is against you. But, it's wild. It's just building an appellate record. There's always judges who are nicer than others. It's not that uncommon. So, the answer would be yes. But now when you look at it from the outside, it just seems so much more obvious, I guess. Live, laugh, toaster bath. You know what I mean? Edward, part of the reason for a restriction last time was the defense discovery violation. Yeah. Not present this time. So she should be free to opine on all expertise. Yes. Right. They said it was too late, that they turned her over too late, but she still was qualified as an expert. Right. So they shouldn't have to qualify her again. But, it's the upside down. Thanks, Edward. Thank you, Marcello, for tuning in from Argentina. So the court wants to have this hearing because the Commonwealth is asking for it. But when the defense asked for it, she allowed it and then denied it out of nowhere while AJ and Eliza Little were flying to Massachusetts. Yep. Clear case law for her to deny, bruh. Yep. Remember? They prepared for that hearing about McCabe's and Albert's cell phone records, and they had everything ready, and they came in for it. And then she was like, yeah, we're not going to have the hearing. We're not going to have the hearing today. Oh, there's Melanie Little's left stripe and swipe in StreamYard. Came for the left swipes. Thanks. I didn't do it yet today, but now you just jinxed me, so thank you. Joseph Kane, most dishonorable. Damages your chi and namaste too, huh, Joseph? Thanks. Ipsy Duxit. You guys are clever. When my brother sends me Dr. Pimple Popper clips, I send him pictures of snakes. Oh my God, I can't watch that, Dr. Pimple Popper. Do not send me any of that. I cannot even stomach 5 minutes of any of those videos, any of that show. I think it's revolting. Thank you. No, I can't thank you because now I can't get rid of the visual of the one show that I even never saw that I thought was so revolting. Yay for not being a cupcake, says the other Karen. Thank you. Thank you. Somebody appreciates it. Thank you for your 20. On top, thanks for the super sticker, KLM. So now it's possible that Turtle Boy's trial will be before Karen Reed. I don't know. I actually know the timing of that. Gas, Melanie, they inverted your screen too. Thank you, Chloe Albert's Revenge. I don't know. Somehow, when I like to mirror it. So when I'm looking at myself, it's mirrored because it's just easier for me when I'm pointing at things. I don't know. Yeah, I guess, yeah. I've never, ever identified as it, says Chloe Albert's Revenge. Thank you for telling us that. 6 should be afraid of 7 because 788, says Cheryl with an S. Thank you for hanging around with me for a month. 8 ran off with somebody's tooth. They're going steady. Thank you for that. All right, moving on now to the there's something else that I thought was funny that I wanted to tell you guys. Oh, I remember I told you about that show, Landman with Billy Bob Thornton, and how I never really got Billy Bob Thornton until I watched Goliath, and I was like, oh, now I got to watch everything that Billy Bob Thornton ever did, and now he's in this show called Landman. So the episode that I watched yesterday, he goes through this. I won't spoil it for you because I don't do spoilers. But he goes through this horrible thing, and they're like, "Do you want to go to the hospital?" And he's like, "No, I just want a Dr. Pepper. Get me a Dr. Pepper out of the cooler in my back seat." Right? Landman is such a banger. He's like, "Give me a Dr. Pepper," and I'm like, "Oh my god, Dr. Pepper has entered the chat again." Dr. Pepper, Sarah Boone. We have emojis for that. Please put some Dr. Pepper emojis in the chat because now we have another reason to use them. Landman. Oh, I haven't watched Lioness yet, but I do love Nicole Kidman, so I will. Yes, Wild Man's mom. I don't know what is up with that. Aussie Insider did a video on this. You can watch it later. It is so creepy. It's a cop that had just retired and he's getting busted by like, is that guy a YouTuber that busts him? He's like with this 11-year-old girl that he swears is 18. And this guy, I don't know if he's like has some kind of like YouTube audit channel. I don't really know. But the guy's 68 and he starts like talking to him. He's like, I'm just here to make sure kids are protected. Like, do you know how old that girl is that you're with? And he's like, yeah, she told me she was 18. And he's like, yeah, no, she's 11. He's a pedo hunter on YouTube. Thank you, Aussie. That was an amazing video. And I had seen a clip of it. And I'm like, I can't play this because I can't really like, speak to its truth and veracity. And I don't really know. Everyone like my mug? What? Mm-hmm. Are you loving this? He's like 68 years old. And so this pedo hunter is like, dude, you know how old that girl is that you're with? And he's like, oh, she said she was 18. And he's like, she's 11. And then he says, like, you're retired. He's like, I'm retired. I'm retired from like the gang, unit, Boston PD, I'm retired. And he's like, okay, I don't know. I'm not a cop. I don't know what you're talking about. And he goes, yeah, Brian Albert, that guy that was involved in, that guy, he was my sergeant, Brian Albert, you know him? He's like, yeah, no, I don't know what you're talking about. Yeah, he's involved in that Karen Reed murder, that guy. That is what part of it that I really thought, not that he was just like, oh, excuse me, sir, will I bend over and pick up that name you just dropped? That is certainly not going to help you here because I don't know who the hell Brian Albert is. But the fact that he said, oh, yeah, he's involved in that Karen Reed murder. Hey, Glara, did you see that? Will, did you see that? Mm-hmm. Oh, his channel, let's promote him. PP Southeast Texas. Thanks, Aussie. Yeah, it was creepy. It was creepy. But the fact that he said, he's involved in that Karen Reed murder case thing, where he's involved in that murder. Like it was like he's involved in that murder. Not like, the body was found on his lawn. No, he's involved in that murder. Crazy, right? Okay. Where are we going next? We have two things to still do. We have the denial of the order for ABC based on bad service by Mr. Brennan. And I think we can do that kind of quickly. So why don't we do that? This is paper number 438. And then we can go back and have some fun with the defense's response to the reciprocal discovery that they want from Dr. Russell. So let's go there. Let me just stop this and then go to this. Very document based today. Somebody said in my comments the other day, can you stop just reading documents? I'm like, okay, what? Have you not seen the comedy part of it? Because, I'm not just reading documents. There's also like a lot of comedy involved. I'm sorry if you don't see that, but, there's comedy. All right, so here's the judge's order. So again, Judge Canoni, her order on Hank Brennan's motion for all the video recordings, audio recordings, interview notes, emails, text messages, and voicemails of Karen Reed in the possession of WCVB TV, Hearst Television Incorporated, and ABC. Now, remember, I'm going to say this loudly. The defense, Karen Reed's team, did not oppose this motion. They did not oppose this motion. They did not oppose any of the motions that were made for cutting room floor outtakes from any TV station and or any journalist. They didn't oppose them. They took no position. They were like, we don't care. Give it to them. We don't care. Okay? So the only attorney who opposed this motion was the attorney for WCBV TV, Hearst, and ABC. And we watched the motion hearing on this, and that attorney came to court that day. And here's the decision. And it is like, this is a decision that is like a lot, there's a lot of legalese in here. And this has to do with jurisdiction, service of process, choice of laws, all those classes that none of us paid attention to in law school unless we were actually going to go into some sort of like international law or appeals or something like that. And so it's a little bit dry. But I will say, to her credit, she did render a 4-page decision on this. So somebody researched this thoroughly before coming to the decision on this motion. And, part of me is like, I should just summarize this because it's kind of boring. But in any event, presently before this court is the Commonwealth's motion pursuant to Rule 17 for everything from all of the interviews that Karen gave to ABC. Okay. And that is, where's my red pen? Footnote 1, which says, at the hearing on the motion, the Commonwealth acknowledged that after serving WCVB TV, ABC's local affiliate, WCVB TV notified the Commonwealth that it is not in possession of the materials sought and had no control over ABC. The Commonwealth therefore withdrew the motion as to WCVB TV. So what the opposition to this motion basically was, look, everything that we have with regard to the things that you want are in New York. Everything's in New York. That's where we keep all of our things and stuff. That's where all the footage is. It's in New York. You're going to have to properly serve our New York office, and you're going to have to properly prove jurisdiction in order to get us to comply with any and all subpoenas to send you a witness on this state case in Massachusetts, where our primary place of business is in New York, and that is where all our stuff and things are stored. Mr. Brennan did not serve them properly. He only served them, I think, in Massachusetts. So let's see. She says here, the Commonwealth has served its Rule 17 on ABC's registered agent in Massachusetts, which it contends is sufficient for the court to allow the issuance of the subpoena for records. ABC asserts that the motion should be denied because the Commonwealth has failed to comply with General Law Section this and the Uniform Act to secure the attendance of witnesses from without the state in criminal proceedings. This is the uniform law. Because the court concludes that maintaining a registered agent in Massachusetts does not eliminate the need to comply with the requirements of the Uniform Act, the Commonwealth's motion will be denied. And I mean, I am going to submit to you that this is basic law. And I don't know if Mr. Brennan's paralegal abandoned him. I don't know if nobody within the office of the Norfolk County DA's office has ever had to compel a witness from outside the state. I don't like how this is titled witnesses from without the state. What it really means is saying from outside of the state. That you can't compel there. It's a long arm jurisdiction question, the long arm of jurisdiction. You can't compel a witness from New York to come to Massachusetts without a court order, number one, and properly serving them, number two. Let me just check something for a second, please. Hold, please. Great. Okay. Here's another denial. Here's another denial. The love of you know. Don't give me a timeout or block me. Is the difference between a chocolate muffin and a cupcake the frosting? Asking for Trooper Paul. Trooper Paul. Kinematics. I'm sorry, what? Bring back the cupcake opening. Seems like disconnect now between cupcakes and recent crappy opening song. Hey, Bomb Posse, didn't you come into my comments and under a different name and try to write the same thing? Did you have to subscribe to the channel today and like hang around for 20 minutes just to come in to give us your thoughts on the crappy opening song? I mean, are you looking for attention today, or did you think nobody was going to notice your comment, or are you looking for attention? Hold on. I think Bompus is looking for attention, is what I think. So should we give Bomb Posse or whatever this is? Because I think the old name was something like similar to that. You know, there's this little tool that we can use now all of a suddenly on where we can go back and look at all of your prior comments on other streams and stuff. So, you know, maybe you better check yourself. I don't know. Just saying. We play Whack-A-Troll here, and we play Whack-A-Troll really, really well. Like, nobody's better at Whack-A-Troll than my moderators. Nobody. That one's already gone. Like, I highlighted it, and it was already gone. Thank you. Thank you, Goodmans. Oh, Mrs. G is here. She likes my opening song. So do I. I love my opening song. I sing it during the day. Yeah, Block Island is a lovely island off the coast of Montauk and between Rhode Island and Montauk, Block Island. It's a real place, and we have like boarding passes. Oh, can I have some boarding passes emojis in the chat, please? It's like feisty. People are feisty today. Yeah. She denied it. And she goes on for a couple of more pages to say that the Uniform Act sets out the procedures for compelling an out-of-state witness to attend a criminal proceeding in Massachusetts and for compelling a Massachusetts witness to attend a similar proceeding in another state. And she goes on to say basically that, yeah, here's the thing, Mr. Brennan. ABC is a foreign corporation with its principal place of business in New York. It has sought and obtained authorization to transact business in Massachusetts as a registered corporation, and therefore it maintains a registered agent in the state upon whom service of process can be made. However, the Commonwealth argues that because ABC has a registered agent in Massachusetts, the Commonwealth does not need to comply with the procedures set forth in the Uniform Act, but can compel the production of records, by serving the registered agent. Trust me, bro. It's like, trust me, bro. Trust me, bro. Well, I don't know what I just did here. Oh, there we go. However, the Commonwealth has not cited, nor is the court aware of any legal authority in support of its position. Here's the thing, you know, when you make a motion, you're supposed to have some case law to back up your position. It's like a thing, you know, case law is a thing that you're supposed to cite in your motions, and you just didn't do it. There's nothing in the uniform law that suggests that requirements may be avoided by the presence of a registered agent. And the specific procedural requirements set forth in the uniform law would not yield to the general statute pertaining to service on a foreign corporation. You know who would know all this stuff? Your process server. Like, it's a simple phone call. I almost feel like at this point, I feel like Lally is just sitting back and being like, go ahead, dude. Do whatever you want. Go ahead. Go ahead, dude. Do it. Do it. They hired you instead of me. Lally didn't make these mistakes. Lally didn't make these mistakes in his initial motions in the pretrial. I mean, you know, I mean, these are basic procedural errors here. Basic. When you make when you make a motion for Rule 17 records from a third party, such as like Bill and Janet Reed, you need to, in your affidavit, really meet the requirements of Lampron. And most of us here are more familiar with the four requirements of Lampron than we ever wanted to be. Basic, yeah, like 789. Right, exactly, John. 789. I mean, Is he showing his inexperience or like again, I'm in the twilight zone here. To hold otherwise would allow a party to circumvent the procedural safeguards agreed to by all states. That's the uniform rules are for all states. They've all agreed to them. You see, it's called the Uniform Law. The Uniform Act to secure the attendance of witnesses from without a state in criminal proceedings. So all the states got together and they decided they were all going to agree on this law. So that if you want somebody to come from my state to your state, you got to serve them properly. And then we have a hearing in my state to decide whether or not I'm going to compel the witness who is a citizen of my state to go to your state to testify in your little criminal case in Massachusetts. You just can't just do whatever you want, right? Really? Somebody said I'm on the rag today. Okay, that person is gone. Wait a second. Before you do that, let me just check that person's history. Hold on. Hold on. Don't do it yet. Oh, it's too late. Wow. I mean, that person is really desperate. Okay, you can do it now, you guys. Mm-hmm. Wow. What a disgusting troll. Okay. Moving on. Done. Thank you. Yeah, it said must have cheated on her. She's on the rag today. Her husband must have cheated on her again. Poor Mel. Well, that goes to show how much that person knows about me. Yeah, you can see their history. You just click on it. If you're a moderator or if you're a creator, Microdots, you can click on a person when they're in chat. You can click on their little picture there, and it will tell you all their history of everything they've ever said on your channel. It comes in very handy during such things as like litigation and things like that. So yeah, you can totally do it. Totally can. Richie's here, everyone. So there's that. The Uniform Act sets out the procedure for compelling an out-of-state witness, blah, blah, blah. Here's the way you're supposed to do it. It applies to requests for in-person testimony as well as to the issuance of subpoenas for documents. A judge of the requesting state must certify that a criminal proceeding or grand jury investigation is pending in that state and that the non-resident is a material and necessary witness. When presented with a complying certification or certificate from an out-of-state court, the judge in the receiving court shall hold a hearing. See, so the judge in this case, Judge Cannoni would have to send an order to New York to say, okay, we need this person as a material and unnecessary witness in the case of Commonwealth versus Karen Reed persecution. And so therefore, please consider this. And then the New York judge would have a hearing and say, yeah, hell to the no. Sorry, but we protect our reporters here. So there's that. See how that works? ABC is a foreign corporation with its principal place of business in New York. Registered agent, blah, 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 blah. Where are we? Did I already go past that? It is this court's belief that contrary to the Commonwealth's assertion under Rule 17, service of a subpoena for documents on a third party outside the state is properly effectuated utilizing the uniform law, regardless of whether there's a registered agent in the state. Oh, she took like four pages to say what she could have said in like one paragraph, but okay, she wants it to be well reasoned, I guess. Unlike many of the other decisions that are merely scribbled on the bottom of the initial motion, I don't know. Thus, while service of the motion could be made on the registered agent, service of the motion, a subpoena for records would be directed to a witness outside the Commonwealth and therefore must comply with the uniform law. For the foregoing reasons, the Commonwealth's motion for all video recordings, audio recordings, interview notes, emails, text messages, and voicemails, Karen Reed in the possession of WCVB-TV, Hearst Television Incorporated, and ABC is denied. Denied. So sorry. So sorry. Meh. I mean, it doesn't say they can't make the motion again. It doesn't say denied with prejudice, but I mean, that is pretty basic, like jurisdictional, uniform law type stuff. So there's that. Well, there's another denial. So for whoever's keeping score out there, another denial on the books, that is paper number 438, which is a denial of the Commonwealth's motion for records regarding ABC, and such as, again, Karen Reed's defense did not oppose this motion either. There was no opposition to that motion. Here is the opposition for reciprocal discovery for Dr. Marie Russell. But before we go to there, we're going to go to the chat. Sage Henning says, I'll take Grassman at straws for 100, Alex. Well done. Hot Wheels loves your intro. Thank you, Hot Wheels. Chloe Albert's Revenge, thanks for the 5. Hey, Judge, make these people you got no control over do this thing we want because, reasons, just reasons. Right, exactly. Exactly. Danielle says, I love the jingle and sing it all day long. Thanks for schmucks. That's for schmucks is my favorite line. That's a great one, right? Thank you so much for the 10. Hang on a moment. Because we are now going to move on to defendant's opposition. But I need to take like a 2-second break. So just give me 2 seconds and I'll be right back. I had to get my hat because, representing microdots and whatnot. Richie's here. Got to get the gear. Oh, look at that. I can rhyme too. It's not just reading legal documents. I rhyme, I sing. There's some comedy involved. You can take my word for it. Well, you know what? Let's take this down. Paper number 441. Paper number 441. Paging 441. Spill in aisle 441. Thank you, Danielle, for your super chat. Thank you, Sherilyn. Sherilyn's always got a funny note. Wait, hang on a second. No, she's so good to me. She says, for when chat is ugly, you deserve another latte. Thank you. Thank you, Sherilyn. Thank you very much for that. I appreciate you more than you know. All right. But I did get my Sphere tickets today with only 6 minutes in the Ticketmaster waiting room. So that was a win. That was a huge, huge, huge win. Oh my God. Remember you guys when we were doing Daniel Penny's verdict? And like there were people in the chat who were like, you're showing Fox News. I'm out of here. I'm like, ma'am, I'm playing CNN next. So like, keep your panties on. I'm just... Did I bite him? Did I bit him? Says, any fool can make something complicated. Takes a genius to make it simple. What do you got there? That's good. Any fool can make something complicated. It takes a genius to make it simple. It's genius. That is a genius quote. I'm looking forward to that Bob Dylan biopic, by the way. Just nominated for some Golden Globes, but it hasn't come out yet. I think it comes out like on Christmas. Timothy Chalamet is playing Bob Dylan. And apparently Bob Dylan's very happy about it. So I don't know. Okay. Here we go. This is the opposition to Commonwealth's motion for reciprocal discovery pertaining to Dr. Marie Russell. So this has not been ruled on yet. The one that she ruled on earlier today was about the hearing that's going to still happen on Thursday. Oh, sweetie, no, says yes. Timothy. Yeah, still so shocked and happy about the Daniel Penny verdict. Yeah, look, we freed Brian Camp together, my friends. For those of you who know about Brian Camp in Hampshire County, Massachusetts. We freed Daniel Penny. This is the power of positive thinking and the power of prayer and following the trial and sharing information about it. And we're going to free Karen Reed too. I'm telling you what, it's going to happen. Because you know what? Good things happen in threes. Threes. The trifecta. Thanks, Kelly. Okay. Here we go. Get out the red pen. And we're cooking with gas. So the defendant is opposing the motion. The Commonwealth wanted, and we covered this, I think it was last time when we did the Marie Russell stream. We did the motion that they made for the hearing, and also the motion that they made for reciprocal discovery and all of the things and stuff that they wanted the defense to provide them with regard to Dr. Russell's testimony, her reports, and, you know, which bite came from which tooth and all of that other kinds of things and stuff, right? So this was filed today at 12:50 something p.m. Okay. Now comes the defendant Karen Reed and respectfully requests that this honorable court deny the Commonwealth's motion for reciprocal discovery pertaining to Dr. Marie Russell. Reciprocal discovery is governed by Rule 14 of the Massachusetts Rules of Criminal Procedure. According to Rule 14 and the accompanying reporter's notes, a criminal defendant's reciprocal discovery obligations are triggered. I'm triggered by this whole entire case. I'm triggered. Only after the Commonwealth fulfilled its own discovery obligations by providing all required discovery to the defense. Yeah. Remember what had happened last time was the reason that the defense turned over some discovery not in quite in accordance with the judge's self-imposed timeline is because Commonwealth itself did not file their certificate of compliance. And since the burden is on the Commonwealth or the state, in this case, it's the Commonwealth, they are required to turn over all their stuff first. Then when they're done turning it over, they file a paper called the Certificate of Compliance, which means they've complied with all their discovery obligations. And then it is from that time that the defense's obligation starts to reveal itself. And set forth herein, the Commonwealth's motion for reciprocal discovery must be denied for two reasons. Ms. Reed's reciprocal discovery obligations have not yet been triggered because the Commonwealth has not fulfilled all of its discovery obligations under Rule 14, and the reciprocal discovery sought by the Commonwealth is outside the scope of information the Commonwealth is entitled to receive under Rule 14. Thank you for pointing this out, Mr. Alessi. I said that too. I said it was overly broad. I think it's a little overly broad. Let's find out what his reasoning is. First of all, the Commonwealth has not yet met its discovery obligations under Rule 14, and therefore it is not entitled to any reciprocal discovery at this time. How amazing is it going to be if Robert Alessi comes in with like full-on New York accent? I am going to be loving it. I'm going to be loving it. Because, you know, LA doesn't really have an accent, right? Boston has an accent. New York definitely has an accent. It's going to be fantastic if he does. I don't know. So I don't know if he does. And so he goes through the text of Rule 14, and the reporter's notes to the rule says that they are clear. The defense has no reciprocal discovery obligations until the Commonwealth has fulfilled its own discovery obligations by providing all required discovery. Okay, and it's right here in writing. If you choose to read it, I will leave it on your screen, but my voice is getting hoarse at this point. The reporter's rule, the notes to the rule also say that it is clear and confirms that it's clear, where it says the prosecution gets its discovery only after it has produced discovery for the defense. Automatic reciprocal discovery to the prosecution commences only after the Commonwealth has delivered all defense discovery required pursuant to the automatic discovery provisions of A1A and any other extant discovery order. Again, this is basic rules of procedure that they're supposed to know about. My biological clock is ticking over here. It's ticking over here. This is another my cousin Vinny moment. Basic rules, Mr. Brennan, of the court in which you are practicing, and you're a Massachusetts attorney. Like, oh my God, like really? Like, no way, like that can't possibly be possible. I mean, I know I only have like a TMU law degree, but you know, I mean, I do know some things and stuff about the law. Somebody once wrote in my comments like, you two idiots about me and Bettero. Did you two idiots go to the same law school as Reese Witherspoon? I was like, yeah, we both went to Harvard. And that woman didn't have a perm because she was in the shower. How's that? I wrote, yeah, we both went to Harvard. Did you go there too? I don't remember you. We should do a stream one time of just like stupid comments and my response, because you know I can't stop. See, because Kat's like, who slipped Melanie the pep and sass in her coffee today? I like sassy Melanie. It was earlier in the stream. There were some comments that were like out of control. And then people had to spoil it for the class. You know, they had to like tell everybody that the motion that I was currently in the process of reading had already been denied. It was like a whole thing, you know. It's like a whole thing. I got all the accents. I got all the accents for you. I'm working on my Irish brogue. I have to perfect it first before I can bust it out. Shower, no perm. No perm. Shower. She was in the shower. You know, Ipsy Dexter. She was in the shower. There's no way she could have had a perm or whatever that was. Like I forget even what Legally Blonde was about. But that's what it is. Yeah, Marissa Tomei just turned 60. You know who's 62? Demi Moore. You know how I know that? Because I watched that movie called The Substance, which, by the way, highly recommend if you're into film and horror. And, you know, it was great. It was great. Cinematography and stuff like that. I had to ask, you know, that robot over there, how old is Demi Moore? And then I'm watching Landman. And then Demi Moore is also in that. And I'm like, she's 62. She looks like amazing. Right? Goals. Hashtag goals. You know who's like over 70 is Bonnie Raitt, who was just with the remaining members of the Grateful Dead, like honored at the Kennedy Center. Bonnie Raitt is in her 70s and she's like goals. That's like goals. She's amazing. That movie is so insane, right? Did you like it, Janine? So good. Thank you, Cusco. Right. Thank you. I'm going to try. I'm working on that brogue. I'm working on it. You're right. The Valley Girl one. Okay. Okay, Leisha. I'm sorry. I'm gonna. Okay. I'm gonna. Kentucky. I don't know Kentucky. I don't know Kentucky. You know who else is my hero? Christy Brinkley. Look at her Instagram. Not now, but later. Look at her Instagram. If you can do both, you can minimize the screen. Look at her Instagram. She just turned 70, I think. She's Christy Brinkley. Amazing. So make fun of my wrinkles all you want on you know, whatever cesspool you're on, but I'm not 70 yet. All right, here we go. Commonwealth is correct that intended expert opinion evidence is subject to automatic discovery under Rule 14. However, the automatic exchange of discovery is not simultaneous. Again, this is something that he should know. Because Lally got spanked during the last trial. He got spanked on this, but oh, that's right. He didn't watch the trial, so he wouldn't know that. Oh, yeah, right. Oh my God, like no way. Commonwealth is not entitled to receive, and the defense is not required to produce reciprocal discovery under Rule 14 until the Commonwealth has completed all of its discovery obligations under Rule 14. Yeah, there's a million citations here, and this is a New York lawyer, I think, writing this. So, it's called research. Rule 14 did not always require the Commonwealth to completely fulfill discovery obligations before requiring some reciprocal discovery from the defense. Oh, wow. Now he's going to go into like the history of the legislation. He's going to school this guy on the law. He's going to school him on the law. You go, Mr. Alessi. You go. And you do pronounce the I at the end of Alessi, by the way. All right. But as the reporter's notes explain, because all I had to do, Your Honor, was actually go read a book and figure this out. I didn't go to ChatGPT to write my motions. The U.S. Supreme Court in 1973 found that a discovery scheme entitling the prosecution to receive categories of discovery from the defense without first providing those categories of discovery to the defense violated due process. Well, Mr. Alessi, I know you're new here, but you might not yet realize, but I'm sure you did watch the whole entire first trial, and I'm sure you know about all of the shenanigans, tomfoolery, and ballyhoo that has gone on and has preceded you. Massachusetts doesn't really give a duck about anybody's constitutional rights. I mean, double jeopardy, not really a thing in Massachusetts. Free speech, not so much a thing. Reporter's privilege doesn't exist. Not that that's a constitutional right, but it is codified in some states, so don't come after me for that. Due process, the duck is due process. In part to prevent such due process violations, Rule 14 was amended to its current version, which unambiguously requires that the Commonwealth provide all required discovery before the defense is required to provide any reciprocal discovery, any of it. And he's got all kinds of citations and laws and case law for that. So there's that. Here, the Commonwealth has not completed its discovery obligations as required by the rule. As this court has acknowledged, the Commonwealth still has outstanding expert analyses and reports that have not yet been provided to the defense. Yeah, like that guy that you say is a dog expert that's going to come in and opine. It's going to opine about the injuries. What's he going to, again, are we playing defense again? He's going to come in and say, these are not dog bite injuries. These came from a taillight, which magically exploded, and it formed itself into little pieces that look like dog teeth, and then all at once, jury, all at once, they scratched a man's arm all at the same time in perfectly vertical lines. Some of them had underbites, some of them didn't, but that is what happened. It was not from a dog. It was from an exploding taillight. Anybody else see like the ridiculousness of that, or is it just me? Moreover, the defense has multiple outstanding discovery requests, and the Special Assistant District Attorney Brennan explicitly acknowledged in a November 25, 2024 email to the defense or to defense counsel that he's still in the process of obtaining the requested discovery. Yeah, those pesky things called Michael Morrissey's personal emails and text messages. Those pesky things that he's still going through to turn over. The pesky things, like his email to the judges. When the judges, when Judge O'Malley, I think it was Judge O'Malley. Was it Judge O'Malley? Oh my God, I can't even remember at this point. Judge O'Malley didn't give Chris Albert his order of protection against Aidan Carney. And so therefore, the judge sent a big spanking to all the judges in Stoughton. All the judges in Stoughton were copied on that email, including the clerk, and a text message from Jennifer McCabe that said that she had lost faith in the system. She was horrified. So Michael Morrissey used his personal email, you guys, to send a spanking to all of those judges. And Brennan's opposition to that motion, really, with a straight face, was, well, this didn't have anything to do with a case. This had to do with a leak in the Stoughton clerk's office. This didn't have anything to do with any pending matter in front of these judges. This had to do with a leak in the dam, and he had to plug that leak with his thumb in his personal email. Are you ducking kidding me? But then we learned that he's actually kind of going through his personal emails, because here's the thing, folks. When you're a public official and you use your private email to communicate on public business, since you're an elected official and all, it becomes discoverable. So allegedly they're going through that stuff, but they haven't turned it over yet. So that's what they're talking about here. That's what I said in a long roundabout way. The fact that the Commonwealth has not yet provided all discovery required by Rule 14 is evidenced by the fact that it is not oh, here it is. Look, the certificate of compliance, which Rule 14A3 requires, and which signals the fulfillment of a party's discovery obligations. That's it. File it, you're done. No big whoop. Done. File your certificate of compliance, and then we'll start. Then we'll start, because that's the way the rules work. That's why we have rules. See? Rules. Rule 14. Rule 14. Look, I'm from New York, but I know Rule 14. Which says, and I quote, when a party has provided all discovery required by this rule or by court order, it shall file with the court a certificate of compliance. And again, he's pointing out the obvious here, but it needs to be apparently spelled out to Massachusetts attorneys and to the judge, who probably will deny this one as well, because, who cares about, procedure and constitution and case law and court rules? Nobody. Apparently nobody. And so, therefore, because you didn't file their certificate of compliance yet, our obligation does not even begin to run. Given that the Commonwealth has not yet provided all of the required discovery to the defense, its motion for reciprocal discovery pertaining to Dr. Russell is premature. It must be denied. It must be denied because it's facially insufficient, and it must be denied. But let's see. Commonwealth is not entitled to the requested discovery under Rule 14. So he's also going to say that in addition to it being not time yet for us to have to turn over any ducking thing to you, it's also improper because it is overly broad, outside the scope. Although the defense is not obligated to produce any reciprocal discovery at this time, the defense has already produced all discoverable information as it relates to Dr. Russell. Goes on to talk about Rule 14 again. It's very specific as to what information is covered by reciprocal discovery obligations. It says under Rule 14, the defense is obligated to provide intended expert opinion evidence other than evidence that pertains to the defendant's criminal responsibility and is subject to subdivision B2. Such discovery shall include the identity, current curriculum vitae, and list of publications each intended expert witness. Current curriculum vitae and list of publications of each intended expert witness and all reports prepared. Okay, so all reports. Oh, I'm on the wrong screen. All reports, current curriculum vitae, which is a resume of an expert, the publications, the list of publications. And reports. Defense has provided the Commonwealth with her identity, her curriculum, her current CV, which contains a list of the publications, coincidentally, and significant cases in which she has testified, and a summary of her opinions. Commonwealth will also be provided with a report, summarize her qualifications, opinions, and conclusions. Yeah, but it's not time yet. It's not time yet. Finally, Dr. Russell also testified at the first trial, which is a gentle nudge to the fact that maybe you didn't see it. Maybe you didn't see it, but she already testified. Maybe you should watch her testimony. Unless the Commonwealth is on notice as to the contents of her testimony, the information produced is co-extensive with the information required for reciprocal discovery. The defense is not obligated under Rule 14 or otherwise to produce expert responses to specific questions or interrogatories. Yeah, you don't get that. Therefore, the Commonwealth's request for responses to interrogatories, a request characteristic of civil court, is entirely inappropriate in criminal court It constitutes a request for information to which the Commonwealth is not entitled. Compare the Massachusetts Rule of Civil Procedure number 33 with the Massachusetts Rule of Civil Procedure number 14. Commonwealth has received everything it's entitled to, and the request it has made for additional discoveries outside the scope should be denied. Conclusion: for the above reasons, Ms. Reed respectfully requests that this honorable court deny the motion for reciprocal discovery pertaining to Dr. Marie Russell, XOXO. Alan Jackson, Elizabeth Little. Oh, sorry. I misspoke when I said earlier that this was signed by Mr. Alessi. It is not. I apologize. Please don't come for me in the comments. Please don't correct me or feel like you have to correct me in the chat. Alan Jackson, Misty and Eddie, and that is dated as well today. So Mr. Alessi did the motion that we read earlier. As such, oops, this one over here, because we did not even look at this affidavit because there was a spoiler. There were spoilers. Let's take a look at it now. This was the motion. This is paper number 440. This is the affidavit in support of the opposition to the motion to exclude the testimony of Dr. Russell, which has already been denied. It's already been denied. So Mr. Alessi opposed the motion for the Daubert hearing, which was denied. It's going to happen on Thursday. And so Jackson and Misty and Eddie opposed the discovery demands with regard to Dr. Russell. I, Robert Alessi, hereby state as follows. I'm a partner with the law firm of DLA Piper. I'm a member in good standing of the Bar of the State of New York. I represent Karen Reed, been admitted pro hoc vice. I make the following statements based upon my personal knowledge in support of the defendant's opposition. And this is how the way that a attorney's affirmation is supposed to read. It's not supposed to say, my name is Hank Brennan. Thank you for doing it right. Although in New York, we don't need affidavits. We just sign affirmations and it's good enough. But it's Massachusetts. Attached here too is Exhibit A, is a true and accurate copy of the June 20, 2024 hearing transcript in which the court allowed Dr. Russell to testify in the above entitled action. We watched that hearing the other day. That's the date. It was June 20th of 2024. Attached here too is Exhibit B, is a true and accurate copy of the expert report of Dr. Marie Russell, including a true and accurate copy of Dr. Marie Russell's CV. So here it is. We're giving you the transcript of the actual prior Daubert hearing that you conducted in open court without the jury present, Your Honor. It's on TV. And here's her report. And let's see if his numbering is correct. 1, 2, 3, 4. Oh, he did it. Do we get extra points? Does he get extra points for numbering correctly? 4, for the reasons stated in defendant's opposition to Commonwealth's motion to exclude, the defendant Karen Reed requests this honorable court deny the Commonwealth's motion to exclude the expert testimony of Dr. Russell, deny the Commonwealth's request for an evidentiary hearing, cancel the hearing scheduled for December 12th to the extent that it is intended as an evidentiary hearing. Signed under the penalties and pains of perjury. Perjury is so painful, not for some people. Some people find perjury really easy, not painful at all, but for, purposes of using the proper Massachusetts verbiage, which is weird to me also, the pains and penalties of perjury. XOXO, Robert Alessi is coming in hot. He's coming in hot. I mean, the only good part about this is that this hearing on Thursday that we're going to cover together live is going to be fire. Like, it's just going to, how could it not be? She didn't do a report. No, you're right. She didn't do a report the first time because remember, they were on a very tight time schedule the first time. She had just reached out to them like before the trial and it was during the trial. And so she didn't render a report. She's written one now because they know now they have more time. They have to exchange a report. So she's done it now. So Thursday should be fire, and we're gonna watch that together. And that's gonna be fun. Justin sends a cash app and says Dr. Russell is amazing. unqualified is outrageous. And Lori just sends. Thank you, Lori. Gather your thoughts. Guys, gather your thoughts, my friends, as we go to the chat for a moment. And as I try and regroup and see if there's anything that I have in my arsenal here that I did not talk about yet with you. I don't know. I want to talk about the Robo Duck hearing, but not during this show. We're going to do a separate show on that. You getting to Harvard? What? Like it's hard? Says Kyle. Kyle, you notice that everybody who ever went to Harvard tells you that within the first 5 minutes of meeting them? Somehow they work it into the conversation. It's like, oh yeah, when I was at Harvard, or they'll just like, name drop Cambridge. Oh yeah, I went to college in Cambridge. Always, never fails, every single time. Tell me I'm wrong. Just ducking around. Love the accent, Melly. Love you. Which one? There's so many. Thank you, Edward. I want the discovery on how the Sally Port video finally showed up in Lolly's possession mid-trial. That's going to be very instructive. Oh yeah. Oh yes. Oh yes. Oh yes. Oh yes. We both. Oh yes. We both reach forward the gun. That's going to be great. I'm waiting for that motion. That's going to be a motion in Lemonade that I really look forward to. I really look forward to that one. That is one of the many things that I think that perhaps Mr. Alessi might pull out of his arsenal. So it's going to be good. Yes, Anna Brown. Dr. Russell reached out to them, and within 3 days, they notified the Commonwealth there was no reports. Right? There was no reason to. They gave her the stuff to review. She reviewed it. She probably called them up and said, "Here's what I think. These are totally dog bites." Like, no way. Like, I've looked at thousands and hundreds and thousands of dog bites. These are dog bites, no question. Here's why I think that pattern of injuries, stuff and things like that. I mean, I don't think they would need to waste time on an appeal right now. Brickout, I don't think they need to waste time on the appeal right now because there's no, I mean, bring her in. Fine. Let's bring her in. We don't need to she's already pushing the trial date out. We don't know if it's going to be exactly to April Fool's Day, but I think that would be totally fitting. But they're supposed to come in, they're supposed to meet and confer and bring their little discovery schedule in with them tomorrow of all the things that they want to agree to and when they're going to turn it over. Zelda's like, I have a client that went to Harvard. I keep telling him to call and get a refund. Well done. Well done. Oh, bite and bits. Bite my bits. We should have an Ozark watch party. I love Ozark. I don't do Discord. There's too much Discord out there already. But yeah, if you guys do Discord, you guys should totally do that. I love Ozark. I love Ozark. Love, love, love. Karen reads not guilty verdict form. Formerly Darla the human became a member. Thank you. Thank you. Because now everyone knows what a great name you have. There's a stiff competition in this chat for best usernames, and it's really fire. It's really fire. Let me see if there's anything here that we forgot to cover. Okay, 402 was allowed. We got that, right? That was the motion to continue the trial date until April 1st, but she really doesn't say if it's going to be April 1st, but I guess maybe that means it is. Scheduling order, jointly prepare it by Thursday. Motion 439 that was just filed today to cancel the Daubert hearing by Alessi was denied during the course of this stream within 2 hours of it being filed. Affidavit in support. All right. Let's see if there's anything else in the confines of my email because, never know. You never know what the paralegals are going to come up with while we're here. Oh, okay. All right. So here's something exciting that I could just share with you is that tomorrow, Alessi lost. I know. Can you believe it, Kyle? If you didn't see the spoilers in the chat, you know why? You know why? Because I got mad. Melanie is getting upset. And the mods deleted the spoilers. And yeah, she already denied it. She's like, yeah, no. No. While I was reading it on the air. She denied it. This trial moves faster than the internet, says Jason. Oh, Richie Schiffer's going to be on the Young Jerks at 6. What time is it? It's 4:30. We got to wait a whole hour and a half. Wow. All right. Yeah. So I'm tomorrow. I'm going to be doing a show. It's going to air on Friday, actually, with Josh Ritter on his other channel, which is True Crime News on YouTube. We're going to tape tomorrow. It's going to come out early Friday mornings. Be on the lookout for that. Bolo on the lookout for a reunion of Josh Ritter and me. One of my new faves. Frigid says one of my best friends in the Navy was Jenny Schmuck. Her actual name was Jenny Schmuck. She would always say she married a schmuck. LOL. Well, I mean, my goodness, what wouldn't you? I can't believe that somebody wouldn't change their name. That's crazy. Never heard of Josh? Check him out. He came on my show the other day. We were doing Daniel Penny, KPT. He was on, and then I saw him. I was watching News Nation last night, and he was on News Nation. He's a talking head. He worked with Alan Jackson. He was Alan Jackson's law clerk in the DA's office in LA when Alan Jackson prosecuted Phil Spector. And then when he became a defense attorney, he was partners with Alan Jackson for a couple of years. So yeah, I like Josh a lot. I like his demeanor. I like his knowledge of the law. And he's great. So if you didn't watch that, thank you. Thanks, Janine. If you didn't watch that, we did a Daniel Penny show. It was a verdict watch show. That was the day that the judge agreed to just dismiss the top count of manslaughter because the jury was hung on manslaughter. So the judge was like, the ADA was like, yeah, we want to just, I don't know, did it? I'll check. Yeah, we want to just, the jury says they're hung on manslaughter. So you know what, Judge, we just want to withdraw that 15-year count. Just withdraw it. Let's send them back on count 2, criminally negligent homicide. And let's see if they can reach a verdict on that. And then it was allowed, which Josh and I were both shocked about. Like, what kind of message does it send to the people of the city of New York? Like, yeah, we were, prosecuting this Good Samaritan for a count that was, maximum of 15 years in prisons, but we're just going to drop it since we know we're losing and, just let them go back and deliberate on the 4-year charge. And then, for the love of the traveling Mary, they came back finally yesterday and he was acquitted. And that was another great day for justice after Brian Camp. We feel like we're getting somewhere over here, maybe a little bit. So much. Let me just see if there's anything new. Let's see. I think let's see. We have, there was a memorandum in order. This was yesterday on ABC. We went over that. That was denied. We went over defendant's opposition to the Commonwealth's motion of Dr. Marie Russell's testimony and to cancel the Daubert hearing. We went over that and the affidavit in support, 439 and 440. We did both of those things today. We then also just went over 441, which is the defendant's opposition to the Commonwealth's motion for reciprocal discovery on Dr. Russell. And then we also went over 442, which was the Commonwealth's motion for reciprocal discovery pertaining to employees of ARCCA. We did it all, you guys. And then we watched, and then we found out that during the course of this stream, she denied the motion. So yeah, if you are late, maybe that's why you didn't see it, but we did everything. We did all the things, all the stuff. Unless somebody can point out to me something that we didn't do. But, it's been like 2 hours and 53 minutes. The denial, Gigadog bits, you don't have to go back, really. I can just tell you. The defense wanted to cancel the hearing for Thursday with regard to Dr. Russell, saying you don't need to qualify her as an expert again because you qualified her already during the first trial. You allowed her to testify as an expert. We did a voir dire hearing. And Mr. Brennan, in his papers, has not brought up any new case law, any new opinions, any new anything, any new evidence. Nothing has changed since the first time you already said that she could testify as an expert. So therefore, it's completely improper. She denied that and said, we're doing it. We're bringing her in. We're going to make her go through another Daubert hearing. My hat says microdots. Is it backwards? It could be mirrored. Thank you, Horse Feather. Shout out to Microdots, who makes some very amazing videos on Twitter. I mean, Twitter or YouTube or both. I'm not even sure. And that is what it says, is Microdots. So, promoting peeps and things. Thank you. Karen Reed's not guilty. Verdict, formerly Daria or Darla the human. I missed my cupcake. Also, AJ's beard. Oh, did AJ's beard go away? I don't remember. Anywhere we can donate Sky Miles for Karen Reed's team? I don't know anything about that. That's interesting. Are you mean to fly back and forth? I have no idea. I don't know. Delta, right? That's Delta. Thanks, Wendy DeB. That's a. I don't know. I'll take them. I'll take your Delta miles, girl. No, I'm kidding. I don't know. I have no idea. Thank you, Midnight Mike. He's the real deal. That's why we do it. Thanks, Mel. Thank you. Thank me. Thank you. Thank you. All right. Is anybody going live, or is anybody live right now? Can we do any sort of kind of like cupcake invasion anywhere, anything like that? Let me see. Let me look. You tell me. Do you want to go? You said Young Jerks was at 6 o'clock, right? I mean, I'm sure any and all donations are happily accepted by the defense team. I mean, we know from the Vanity Fair article that Karen happens to be $5 million in debt and continuing to her defense attorneys. And so, there's that. Yeah, Dicey Defense Diaries is live. Let me just see when they started to see. I mean, I redirect to people who direct to me, so that's the way we do it. That's the way we do it. Yeah, let me just see when did they start? Let's see. They're doing Luigi. Well, I want to see how they pronounce Mangione. I don't know, but he's got his I don't know when he went live, but we can send you over. Listen, you want to go over there? It's like a vertical stream. I don't know when it started or anything like that, but tell him we said hi. Mob says Mangione. It's not Italian. It's not East Coast Italian. Chloe Alberts, bits, bites, and bites, and bites and bits. Appreciates my knowledge. Thank you so much. Thank you so much. I'm not gonna argue anymore. I'm not gonna argue about the pronunciations. Tomato, tomato, potato. Not doing it. Not doing it. All right. You can go over to Defense Diaries. You can say Cupcake Invasion. Woo woo. He's gonna read the Luigi Manifesto. We're just gonna call him Luigi. You know why? Because Kathy does. Kathy from Gossip Rumor and Innuendo is like, I'm just gonna call him Luigi. So that's what we're gonna call it. I'll allow it. We're just gonna call him Luigi. My Italian is different than your Italian. All right, my friends, head on over there. When I hit end on this, you're going to be teleported over there to Defense Diaries to do a cupcake invasion on Bob Mata and freak him the duck out. Okay? See you guys soon. Make sure you have notifications set. Make sure you smash the like button. Thank the moderators. And, stay cool, stay kind, stay classy. It's really not hard. Really, it's so not hard. I'll see you before Thursday, but we will be back doing the thing of the Karen Reed hearing, but we got stuff before that. I got something exciting lined up. I just am waiting for a confirmation of it. So there's that. Lori, thanks for coming in with the last minute 5. Is there any way actually she can deny Dr. Russell? I mean, how, Melanie? How? No, I don't think so. I don't think she can. I just don't. Maybe she wants to dot all of her I's and cross all of her T's and make sure that her paragraphs are numbered properly. I don't know, Lori. I don't know. I don't think so, though. Go on over, tell Bob I said hi. Goodbye. Safe travels, my friends. Do the things that YouTube likes, okay? Smash it. Stay cool, stay kind, stay classy, and peace.